Thank you for coming on again this morning. We'll resume from where we left off yesterday afternoon. We got to the point of participation as the element of the Aboriginal Torres Strait Islander placement principles. One of the issues that we've identified in the inquiry is that identification of itself is an issue. Not just the identification of children as Aboriginal, but identification of the appropriate people to participate in the decision making, in the family group conferencing, with Western notions of what family is, limiting and potentially excluding other significant people from participating in the decision making. I note that CACYP have been engaged to do the family finding families work, and they've advertised this week for an ethnographic project officer to do that work. The question we would have is, why not go directly to the local level?
Do you want me to speak to this one? So this was what we touched upon yesterday, Council, in relation to an initiative. So we're wanting to demonstrate by way of the initiative is basically a trial, and in partnership with KWY, we're wanting to test exactly what you're saying, that is, using the local relationships in communities in order to be able to establish and test the trial and get that up and running without having to go through the full registration with all of the RATSIO partners. Our arrangement with KWY is that they will auspice the funds to assist.
But they themselves aren't a RATSIO.
No, and in terms of the actual project work, to do that particular task, you don't actually need to have the RATSIO accreditation, or like you were referring to yesterday, I'm trying to think of the word, the gazetted organisation. Yeah. So what we are hoping to do is, in a very short period of time, demonstrate that that is the model that works. Then we can ramp up and start having individual agreements with each of those stakeholders in community.
Are you aware of, well, I believe with the previous comments that I made yesterday in relation to this discussion, was that there has been a model in South Australia that has been evaluated and highly successful. It is, from my view, I guess, an oversight of the system, not acknowledging the work that has been done, the work that has been proven, the work that has actually yielded results, because that evaluation details the success of that program. So I'm trying to understand the department going forward without acknowledgement of that knowledge, that what's on record about what is successful, and the fact remains that there is the need to not keep on spending in areas in which we know where the answers lie. I'd like to hear from you about the knowledge of the system, because I am aware that there are people in your organisation that have full knowledge of those programs and those particular initiatives that yielded excellent results for Aboriginal children and their families with respect to engagement at a local level, of the local level intelligence, that going down the track of funding an organisation that is relatively new in the space does not make any sense.
Yeah. And Commissioner, if I start by, I know some of the conversations that we've recently had and you acknowledging this particular programme of work and that evaluation which I sought to go and review and look at. after you only told me last week, and you're probably right in regards to knowledge in the organisation, and I fully accept your position that you have in regards to what works, and that concept has already been tried, tested and evaluated. So to acknowledge that, I think what we're describing at the inquiry today is what we've done right now, which is we've embarked on a small piece of work, which is funded internally by us, no additional funding in regards to really having a look to see if we can get people returned home, and we want that to evolve. And it is a commitment of Adam and I to consider exactly what you've brought to our attention in regards to some additional phases of this particular programme. And I think the conversations that we've had today will be very much shaped by the information that you've given us and what we need to do. I think it's fair to say though that this initial part of the work, with all due respect, I think those conversations have already occurred. So we wholeheartedly, agree with what you're saying, that it won't meet this local need, and we need to do that as we think about planning going forward from that small piece of work.
Because I am alarmed to see that the organisation is looking to recruit someone with an ethnographic background. For the life of me, I'm trying to understand how that particular professional background has more intelligence about the Aboriginal child and their family than the Aboriginal community itself, and the ability to engage with the Aboriginal community to do that very piece of work lies within the community. I am struggling to try and comprehend the justification, the rationale, in the weight of all the information and the storytelling and the reveal from the Aboriginal community, not just with the work that I've undertaken, but with the history of what's been spoken to about how you actually connect Aboriginal children to their families and to their children, or to maintain their cultural connection. It just seems so far removed from what the message has been.
Well, aware that I'm obviously still under oath, I know nothing about the recruitment of those particular positions, but I'm committed to having a look at that with Adam in regards to if that causes any concern with our partners. But I don't know if you've got anything.
I'm reflecting in terms of my actions and what you've just said, Commissioner, and I think it would be fair to say that in my eagerness to demonstrate a model that works, I haven't done the due diligence in terms of looking at what's happened in the space before, referring to exactly what you were talking about. And I'll commit to going away and doing that piece of work. Even though it is a trial, it is about demonstrating and then building something bigger with community. I think it would be the next sensible step to me seems to be to investigate what you've raised and see what other connection points. It sounds like there's some real synergy. In relation to the position advertised, I too am not aware of that. And in my conversations with our ACO partners, it was very clear in our mutual understanding that this was about local community conversations with family, which is consistent with what you've said. But I'll have to go away and find out about that position and come back to you.
Thank you. Thank you.
I take it that simply from the fact that this project has been put into place, you would accept that the family scoping that has been done in the past has not been adequate. Is that fair to say?
I think it hasn't met expectations, definitely. If I could say, it's not through lack of intent from staff, it's purely capacity and workload, and that's why we spoke about making sure the priority work is separated from the mainstream work.
Certainly.
I think the other point as well, Council, there is that we now take up the leadership of an organisation which is evolved and certainly grown, and having been in the agency before, as Adam, even just that within the last sort of 10 years, there is projects and programs that are no longer in operation, and there's some various sort of I guess evaluations of those programs and intent, and staff group themselves, community themselves will tell you where some things. So part of our role is to listen to that and actually go back and to, you know, to go back and actually have a look to see what were things happening. And I, for one, am not fearful of leaning back into where things were proven and were driving the results and the outcomes that we actually wanted. And just because it's something that we've done before, that doesn't bother me at all to, you know, represent a different project or go back and have a look at what the concepts in there were good or not. In regards to family finding, I think I certainly know there's a history really with different teams that have attempted successfully, some not others. And I think we find ourselves in a way now with an opportunity to go back, and this is a real immediate piece of work, because we think that there is a real public health crisis here in regards to the number of children that aren't with family. So we really want to do that, but we are absolutely committed at going back and having a look to see what else we need to do.
Because that responsibility about finding family belongs to the Aboriginal community. Like, that is the message. But I understand that particular piece of work that you're now focusing on is on children in residential care.
It is.
So those are already in the system.
Yes, that's right.
Yeah, just to make that distinction for the
that's
record.
right, Commissioner. Yeah.
Thank you. Who is it that gets to decide who participates in the decision making and who's included outside the Western idea of nuclear family, the kin and the cultural mentors, the community leaders and so forth?
My understanding of the policy that applies around particularly family group conferencing is that there should be self-determining principles. That is, families should be able to nominate. I think the complexity in terms of that being the experience of families coming to family group conferencing comes back to our cultural proficiency and our the clinical focus on primary attachment and a very Western model of a family. That's where, if you then look at how the power is divided amongst participants, the power sits with the individual or individuals who have the Western and very nuclear clinical assessment of what family is. So the policy may be there, but in the absence of that cultural proficiency, we can see where there would be experiences of family where they don't feel that the cultural definition of family is being respected in that space.
And so what is going to happen to address that in the immediate future?
The one thing that we've got underway at the moment is actually there is some more broader consultation to sort of understand the principles about who is actually involved in decision making, and we're actually asking community and families and to sort of participate in that, so we can get a rich picture around. We have an assumption where we feel that the principles around participation for communities and families and children, I think, hasn't been fully explored or even adhered to. I think we need to sort of there is an immediate now, or a question out there in regards to the decision making and who's involved, how people see their participation in that. But we assume that we think that we know what that answer will be for where we need to build on that there.
And how is that consultation being undertaken?
My very small knowledge about that council is that I do know that there has been some communication out in regards to our website, in regards to opening for invitation for people to seeking counsel on that from a number of people. But I'd have to take it on notice, and I can furnish the inquiry with a full response to that, so you can detail knowing what that is.
Because that website would assume a number of things, wouldn't it? Assume that people have access to a computer, assume computer literacy, assume literacy
Indeed.
even. So in terms of genuine consultation,
Indeed.
there might need to be some more.
Yeah. Forgive me, it might be that what I've seen is how we've done that through our carer community and our kinship families that are connected. That might be my reflection of it, so I'm happy to I'm happy to make sure that I correct or really furnish the inquiry with what exactly is happening there. But I do take on your points in regards to the insight that I've given you there. I do know there has been some written feedback from carer groups, kinship carers from our carer community.
Thank you.
Is that the extent of the community engagement?
I'm not sure, Commissioner. I'd have to sort of take that on notice.
Yeah, in terms of the Aboriginal community involvement, I guess it goes back to the previous question that I asked yesterday in relationship to the level of engagement with the Aboriginal community.
Yeah.
So I'd be keen to know
Yeah.
in that developmental process
Yeah.
what that looks like.
I'm more than happy to take that on notice. So. But do you know any more?
No, I'm not across that, sorry.
In the hearings with the workshops with the DCP workers, a number of the barriers to participation were identified by your workers, and with respect to the reluctance of families to engage with the department, which comes back again a bit to the previous discussion about consultation and asking who should be involved. But some of those were shame, disconnection from family, entrenched trauma, and just simply not wanting to be involved in any close proximity to the child protection system. How can the department build trust within the Aboriginal community with a view to supporting participation?
I'll start maybe, and then you can just talk about some of the things that we're doing, because what was alarming to me when I got the preliminary inquiry from the Commissioner was where she'd highlighted those specific that specific feedback from those actually from her consultation. So Adam and I, along with the rest of the executive members, did get together to really understand that and what we were going to do to take action for that. So it was very much around, we need to act on this if this is the views and the information that's coming back. So I'll let Adam outline a little bit about what we're doing in that regard.
It is, and I think it needs to be a multifaceted approach. The first part is the valuable insight you've received from our staff, and having regular conversations with our Aboriginal staff. There's a whole bunch of work we need to do right there. I think for those families that are prepared to engage with the child protection statutory system, as we were saying yesterday, it's important that the option is there to engage with Aboriginal people. At the moment, our Aboriginal staff network report feeling isolated, not connected, not having a strong voice, similar to what we hear from families. So part of the work, and it starts with the cultural supervision, but also we've had conversations at the All Staff Network for Aboriginal Staff about some aspirations, that we have a collective wealth of knowledge and cultural authority, and having that plus the relationships to community, we should have a stronger voice in the organisation when it comes to policy, implementation and various initiatives. So there's a piece of work about that cohort being more recognised and having more sophistication in terms of influence of the broader child protection system. Separate to that, I always think back to my conversations with families where I completely understand, even my own family doesn't want to have contact with the welfare, and when you dig a little bit into the trauma, it's completely understandable. So my question to our system is then, is the statutory system the best way to go forward with what's been raised as either a concern or an issue? So I'm of the view, when we talk about the continuum of the child protection system, that DCP is not always best placed to be having those conversations and engagement. And I think, Jack, you talked a bit to that yesterday in terms of it's all of the other stakeholders, and Ratios I see playing a critical part in that. So moving forward, they're the things that we're aiming to build to make sure that our Aboriginal staff network has status in the organisation and influence, that they have relationships with community, Ratios and ACOs, but more broadly that there's the opportunity for us to say, we've received this information we're concerned about. We'd like someone appropriate to have the conversation with the family and not us just directing and potentially traumatising people. So that's the aim in terms of that real partnership.
The other aspect as well, Councillor, in regard to Adam touched on the training, and we talked about the cultural supervision. The other aspect for us as well is around truth telling. When you have the identification of that narrative coming back to how people feel with their engagement, there is an element of truth telling in that, and I go to that concept as well around what we want to incorporate within our training around the two rights. So what I mean by that is quite often we go to that place of where there's an assumption here that, you know, our staff group, our department, our represent, you know, how we represent it is done, you know, in a way, in a manner, in a practice around a good best practice, and it's really ensuring that the agency is aware as well that just because of perception in the community or within any interfaces that we have doesn't necessarily mean to say there's one party is wrong and one party is right. This is where we actually have to build a really strong foundation in regard to that sort of truth-telling, embed that in our training, that these impressionable aspects are indeed the staff group that are coming from a very evidence, research, you know, theory sort of type of application here to their engagement. There can be two rights here, and that's how we get that great strong engagement and doing that. So yeah, those aspects are very much front of mind and front of centre of my mind in regards to that feedback.
Can you see any strength in perhaps having a completely separate Aboriginal run and managed branch of the department?
I can speak to that from the Royal Commission I participated in interstate, that it was discussed, and there's some significant benefits to a model like that, but there are also some risks. Mm-hmm. I see the benefits in terms of if you ensure that each level in that structure has the cultural proficiency, because you have Aboriginal people all the way through the decision making, the experience can be significantly different in a positive way for families. For me, the only risk, and it is something that could be managed, is you don't want to make Aboriginal business an orbiting moon around a mainstream service. You want to embed the cultural knowledge and proficiency, is the language I normally use, but you want anyone working in that space to have the same understanding in terms of, or at least an acceptable level of understanding of the significance of culture and the importance of engagement with Aboriginal families. So for me, I think somewhere in between is probably where I would be looking if it was to be a trial, and I'm only going off the conversations from interstate, but the options around making sure that those staff are connected and supported is something that you can do without necessarily separating. But even if there was a separation, you could still apply the training and the cultural immersion to the non-Aboriginal workforce. But I just do worry sometimes that where I've seen when we specialise in an Aboriginal service, that people say, a bit like the child abuse report line, people say, well, that's them, they do that. And that's not bringing society, I think, on that journey as well.
And you'd have to admit, across South Australia, in terms of our government agencies, that blended model is really what is in play, whether you look at Aboriginal health, whether you look at education, whether you look at other agencies like, you know, I said health, didn't I? But that is the key organisation with education that has a central Aboriginal business unit with a myriad of Aboriginal programs with Aboriginal leaders. So I guess, and that at the moment, barring yourself as the deputy who's of, you know, an Aboriginal person, that whole, I guess, aspect is absent in this organisation in terms of Aboriginal centred coordination around the Aboriginal agenda in DCP.
And I think you're right, Commissioner, because when Adam was talking, I was thinking about the Aboriginal health model, which is obviously clearly demonstrating the outcomes that, you know, that the community and and Aboriginal people. I think for us, notwithstanding as well, we're only 6 months in to our journey. It is something that I think is a huge consideration for us. We really like to see where the amendments to the legislation takes us. We'd really like to see where other, such as the outcomes of this inquiry, might take us, to actually then have a look to see how do we need to structure what we need to do. Regardless of that, even if it wasn't happening, I think there would be an aspect of that would evolve as part of the organisation, with the deep, strong commitment from both myself and Adam in regards to what needs to change. But in absence of some of those other sort of what potentially could guide and shape how that is, I think, Commissioner, I think you're right in pointing out that there's probably an aspect of that, and like Adam says, of how that evolves and how does that look in our structure going forward.
Thank you. There were particular issues raised with respect to emergency removals, being that no notice to families or opportunities for them to have any say in the decision making about temporary placements. Yet it was clear, and it's clear from the case reviews that we've done, that even in the situation of emergency removals, those decisions have been premeditated. They're not decisions that are made as a snap decision, so there's no opportunity to engage the family. That's a deliberate decision not to do so. The other thing we heard was evidence that occurring especially in the removal of infants from the hospitals. Again, that removal decision has been made in advance with no notice whatsoever to the families, or even to the service providers and the hospital staff. In fact, we heard that hospital staff are told not to tell the new mother that her baby is about to be removed. What do you have to say about that practice?
Yeah, sure. I think for me that's both alarming, but in some ways not surprising. It's come up in the last Royal Commission as well. All I can say is that I will always defend the work of our staff, but I'll never defend the indefensible. And what you've described, I can't find a rational response to support that action. It's disempowering, it's traumatising, and it's not necessary in our compliance with the legislation. But I would gladly look into those matters more, because they're the things that we need to know about so that we can take action. But I would genuinely apologise to those families for that experience. It's unacceptable.
And when you talk about trauma, it's traumatising for the hospital staff as well. They find that enormously traumatising. So across the board, it's unacceptable behaviour, isn't it?
And I think there as well, Council, is that there is some work actually being done with child protection services in health. I know that the repositioning and prioritisation of the work that they do. I know from experience and listening to those aspects of when those events have occurred, really unpicking what was happening there, and there's things such as it can all depend on the time of, if it's on a weekend, if there's resources that are there, not there, obviously if the births occurred. So there's lots of things that I think as part of those statements made by parents that we do need to really look into. But I do know that there is work already happening around, as we spoke about it yesterday, in regards to my concerns about that, even to the point of where Adam and I have discussed, potential looking at delegations in that particular manner as well.
What sort of delegations?
I think it's just about what's not, and it's not a commitment that I'm saying here, but what's not off the table really is if we can look at opportunities of where removal of Aboriginal children, we need to make those decisions about those removals.
So decision making happen elsewhere as opposed to...
Yeah, it happens now as part of the practice.
Yeah, the conversation about delegation that we're exploring is because of examples such as you've provided, do we need to look at increasing that delegation level, so from practitioner or
Yeah,
supervisor to manager, etc.,
Yeah.
just so there's additional eyes, and part of that would be a cultural assessment as well.
Is that in regards to infant removals in hospitals, or just more broadly in regards to Aboriginal children?
It's a discussion point still, but I would
Yeah.
assume if it was to go forward, it would be in all cases where emergency removal's considered, or if a decision's made to go to longer term orders.
I think it speaks to it. I guess it speaks to the. Regrettably, you know, we're not sat here having been in the role for 2 years. We are sat here having been in the role just for several months. But these are all things that we are looking at that are attempts to really look at these particular matters. So, as I said, it's not a commitment, but it's something that we've literally said. That is also as well something that we might want to, look at as being a particular aspect of where we could definitely have that higher level oversight into and that cultural consideration at that higher level for Aboriginal babies.
Yeah, because I'd be keen to understand how that works with family-led decision making, in terms of that particular principle being deployed and what that looks like with elevated delegations.
It's really just to have an extra layer of insurance over those emergencies, but I've also seen some of the applications for long-term guardianship and some of the other where the delegation doesn't automatically flow to higher levels. And as I mentioned yesterday, in some of the reviewable processes, at a certain point the cultural lens stops and just clinical continues. So they're the sorts of conversations we're having, just to make sure exactly what you're describing in terms of family-led decisions is captured at each part of the process. And I couldn't say confidently at the moment that it is.
It's something I was going to raise later on, but I think it's relevant to bring in now. South Australia is one of only 2 jurisdictions where we don't actually recognise legally a fetus in terms of a legal entity, which means that the capacity for any involvement is not until the child's born. In Victoria in particular, some other jurisdictions, Victoria, Queensland, they have in their legislation the capacity for the department to actually take action very early in a pregnancy. And so in terms of prevention and early intervention, would you say that it would be worthwhile to amend the legislation to enable that very early intervention and supports being offered, rather than the first a pregnant woman knows about something being seriously wrong is when department workers are at the end of her hospital bed to remove her baby from her?
So I think there's a my response to that would be that has definitely been part of the feedback as well of the review of the legislation, and that is obviously those matters that feedback is being considered at the moment. In regards to the legislative requirement, I think it's there is also as well that, as you said, that broader sort of identification and entity from a legal perspective, and I'm aware that we have been in some discussions about that, but it would be obviously the consideration of the government in regards to what the outcomes of the legislation would be. On the second note, I would say about in regards to pregnant women across the state, there's obviously a lot of work in both early childhood child development in regards to the work and the partnering with ACCOs in regards to children and family services, the work that the Department for Human Services are doing with pregnant young mums, and of course the work that we do in regards to an early intervention with early and effective intervention as part of the child protection system that we would do. So I think what we don't have is we don't have that sort of coercive element of any legislation to enable that to happen, but we certainly know that those services are offered, encouraged and participated for those expecting mothers. And I think the more that we can look at Aboriginal expecting mothers and having community-led services and where they feel supported and feel feel included in those particular service provisions, I think that's the better of where there is a level of participation from the expected mothers rather than a requirement, you know, all of that sort of level of voluntary sort of participation and indeed sharing and the, you know, them having answers to questions and concerns that they might have about their pregnancy as well. So I think the more we can put into the community around that, the better. And I think there is huge steps and even more from a government perspective that I'm aware of, focus and effort in those particular, having those particular community-based service provision out there for young and expected mums.
At the moment, there is a project between Health and Relationships Australia SA around unborn child concerns and referrals to family group conferencing.
Yeah.
What is the likelihood of the department, including health and human services, in the ability to refer to a family group conference for a child in need? What is the likelihood when there is actually a call for those two organisations and others, I imagine, to be able to make a referral to family group conferencing? And if not, what is the barrier to that?
So, Commissioner, do you mean as in how the referral's been made or a self-referral?
At the moment, only DCP can make a referral to a family group conference. Other helping agencies are not able to do that. But there is that initiative at the moment underway.
Yeah. And as you say, Commissioner, it is definitely with intent to look at building on that concept. Notwithstanding that, and I can speak in regards to the Department for Child Protection, maybe not some of the other agencies in regards to that, would be about having family group conferencing is a referral mechanism to establish that discussion. I've been wholeheartedly saying across the agency, and it comes back to that sort of participation as part of the principle, is that a conversation and discussion around the young person and the people that are important to them should be a normal practice regarding bringing people together for those particular discussions. Yes, we know that the principles and the more formal family group conferencing practice is very much a different sort of structured mechanism, but just to lean into that prior to any referrals that should happen there, it should be about that concept of bringing together people that are of significance to that young person. Should be, you know, a normal practice within the agency. But going back to your original question, Commissioner, about having a mechanism for other referrals into family group practicing, I think I would like to see more family group practicing across the agency. I would like to see all children having opportunities of accessing those types of services and programs going forward. And it will be, you know, it's a case of when that, when those funds become available, what sort of types of service provision have we got? What sort of types of service have we got to do these? So that would sort of open that out to more than just currently at the moment dedicated resources and dedicated services that we've got to deliver that.
Because family group conferencing is such a crucial forum in which to afford to families in keeping them out of the statutory end of child protection and enabling and empowering families to make decisions to keep their children safe.
Yeah, and hence the reason why I sort of said the practice of bringing together people to talk about, the safety of that little person and supports that might be needed to the family, even outside of a system, should be a primary focus and a principle of practice that we need to encourage more.
Is it the case that the appropriate way to do that would be to support the ACCOs to do that work?
I think it's a conversation with ACCOs, but with RATIOs as well.
There's only one RATIO, and that's an ACCO. I'm just getting confused with the language because a RATIO is an ACCO. A RATIO is just a function of an existing one only ACCO in South Australia.
Yeah.
I just got to make that clear.
So I would share a different view, and that is, to me, an ACCO is an Aboriginal community-controlled
That's what it means.
organisation in any form, whether it's
Yeah.
registered in child protection or not.
That's right.
I think there are ACCOs that can provide great contribution and value in this space, but are not yet registered to deliver some of the services through child protection. I don't believe that there is a preclusion for them to be part of the conversation when we talk about who should be doing or hosting the family group conferencing, because as we were talking about, people not always feeling comfortable with Department of Child Protection, and that commitments to self-determination mean that the host or the facilitator for those family group conferences should really be close as possible to the family, embedded in the community, and that's where I'd see the opportunities. Once we've got an assessment that says this is working, and we all know that it will say it does because it simply does, when we start to design how we ramp this up and how it moves across the state, that's where I see the opportunity for those smaller organisations that are not yet registered for us to get into that space.
Yeah, so I don't have an issue with what you're saying just there, but you're referring to RATIOs as if there's a multitude, there's only one.
Yeah.
At the moment
At the
in South
moment, it's only
Australia,
one. Yeah.
which is an ACCO.
Yes.
But I think also as well,
If you're talking about a plan, then
we're thinking
then that's what I need to hear. But
yeah.
the response makes it sound like there is a multitude of RATIOs.
Yeah.
Yeah, that's what I just want to clarify with you
Yeah,
guys.
and I think, Commissioner, I think what we're referring to is as we progress, we absolutely should be looking at more RATIOs. So in that context of them being, that plan that you mentioned about what we need to do, how we need to have more RATIOs gazetted in South Australia is something that we need to definitely.
What's the process for an ACCO becoming gazetted as a RATIO? Do you know?
So my understanding, Council, is that there is a registration, there is an application to do that. There is a requirement for them to demonstrate their capacity in this particular part of the work. And I think then obviously part of that would be around then the establishment of the work that they're doing there, and of course there's a funding aspect of that as well in regards to them having some sustainable funding to do that. So that all collectively together becomes part of an application process too. And as I said to you yesterday, my understanding is the application process is one aspect of it, and perhaps not over prescribed, but the work that they're going to do, and clearly some of those fundings of those local communities and those organisations need to be something that's a further consideration around what it is.
Yeah, I'll go back to my earlier points about Aboriginal community engagement. To what extent will the Aboriginal community have a role to play in approving an ACCO as a registered Aboriginal and Torres Strait Islander organisation
Yeah.
for the purposes of being gazetted under the Child Safety Act.
Yeah, yeah, that particular part of the gazetted under the Child Safety Act is where they need to demonstrate the work that they're doing. That was against a particular part of the Act, and then obviously how that funding is going to be. But the Commissioner's right in regards to the conversation, the consultation with the community to establish what that is, and that's part that we need to do as well.
Because at the moment the Act speaks to being a source of consultation in regards to a placement for an Aboriginal child.
Yeah, that's right. Section 12.
Yes.
Yeah.
Which, as you know, my
Indeed.
preliminary report speaks about more than just placements, all the significant decisions, key decisions in relation to an Aboriginal child. Yep.
Absolutely, indeed, Commissioner.
The Department's Manual of Practice states that Section 10 of the CYPS Act requires workers to actively seek the views of children and young people once they're considered developmentally capable of expressing their views. Children and young people are often able to express themselves from a young age if appropriate support is provided. However, in the consultations with your staff during the workshops, it was a complaint that children are given very limited opportunities to participate in the decision making. And that was borne out by the evidence that we've heard across the board in this inquiry as well. Do you consider that the requirements of the Act and the Department's own policies are being met in this practice?
I've got a few. I think we're definitely lacking in that space, and we're again not unique. For me, and I think back to recent professionals meetings around particular young people where I've participated, and often ask the question, who's met the young person? When was the last time we saw the young person? There are staff, particularly for children who are in our residential care homes, that don't always get invited to the conversations where the decisions are made. So I see great opportunity for us not only to make sure that the people that are there at least have contemporary knowledge of the young person, but there are ways, and we talk about Create Foundation, we talk about the referrals and queries through commissioners. There are ways our own system can make it safer for children to be able to have a voice. One practice that I would use in another jurisdiction is for each case conference we would have a photo of the young person, and we would have clearly agendaed items that talk about different domains and different views from the young person that had to be captured in a safe way and then presented at the conversation. It can be desensitising for staff when you have such high numbers of traumatic matters to deal with, but there are things that we can, and I'm happy to commit that we will take on to elevate the voice of the child, because ultimately that's who we're here to serve in terms of our roles.
And there has been some additional funding into Create specifically to ensure that we capture more around the voice of the child here in South Australia. And this was certainly underway before I arrived here, but it was actually launched just over a month ago. And primarily it is about those young people, as Adam mentioned, there's sometimes where the participation is a bit overwhelming for them too. So we've actually set up a new platform in regards to, it's called Our Way, Our Voice, My Views. And it is a particular an engagement tool now, which is a platform where children and young people can actually tell us about their experiences, can actually feed into the things that are working for them and not. We've had a really, even though it's only a couple of months, we've had a really good uptake, and clearly we've been doing some promotion around that particular platform in our residential care, where obviously our young people have access to mobiles and things like that, so they can do that. And I've certainly been reading a lot of those particular matters that have been coming up, those young people. So I think, although even it's just in its infancy, that's another tool, not the only, another tool for us to sort of try and ensure that we get that feedback into their insight and their views into, their engagement with us.
When you look at the reality for a young person who's removed from parents, placed into care, particularly children in residential care, there's a cycling of staff that come through there. Often the staff in residential care are students themselves who are doing sessional work. Over and over, we see in documents presented to the youth court that one of the main criticisms of young people who have come through and been cared for in the department is that they do not have a parenting template. How can you possibly develop a parenting template when there's nobody that stands in the place of a parent in your life?
Well, I think residential care is certainly, I can only talk from my views, having last been in the agency over 10 years ago. There has been a significant shift in regards to the type of therapeutic environment, and with the absence of those, that family-based environment, of where I think the agency they've really commenced a journey, I guess, really, in trying to recognise that, and really being a lot more therapeutic, home-like than it was before. Do we have some way to go? We still have some way to go. There's no doubt about that in regards to that. However, in regards to the staff group, we know that residential care is not an ideal form of accommodation and for our young people, hence the reason why our efforts is in regards to reducing the number of young people that we do have in those settings. Likewise, I think, as I said, it was very evident to me as I came into the agency the differences that there are now into those more residential, smaller home type engagements, with the participation in life skills for children there, in regard to that, cooking, home life type of scenario. We can't not, I guess, acknowledge that, staffing on a roster is, staffing for people coming to the house. There is times where we look at a care group for a particular house. We would like to really move towards that with our partners, to see if we can look at more stabilising care groups to look after young people. But it is critically a challenge for us at the minute. But I think from that, where we were to where I am now coming back to the agency, there's definitely been a significant acknowledgement that things have moved, but I think we do have some way to go still.
I think so, and in terms of the role of residential care, it's become more of a destination, and it's because of the volumes coming through in terms of investigations and then open cases, and obviously children caught up in all of that. So this is the part we talked about expanding rapidly. I see a role for residential care, and notwithstanding your point, Council, that it is not an environment where a child or even siblings can feel that connection with workers in a more familial type setting. Its function is really intended to be a point of assessment and almost like a holding pattern or a waiting room while we find or build the appropriate placement for that young person.
That's not the case, because
It's not, because we see kids that have been in residential care for years.
and exit out of the system from their residential care basis. If you just look at South Australia, very small jurisdiction, like that volume is not in comparison to the volume in Queensland, yet our rates as a very small jurisdiction in comparison to Queensland is equal to their rates of children entering residential care. And also the very young ages of our children from our Aboriginal community entering into residential care.
Yeah.
There is a wealth of research about the negative effects on life outcomes for any young person growing up in residential care.
Yeah.
It does not replace family. It can never replace family. I want to hear from you in terms of what plan you have in terms of those children that are currently in residential care. And because I did hear with your priority work in
It
getting
is under 10s.
out of residential care.
Under 10s and Aboriginal children.
So that's, that sounds very promising. But I just had an experience on Thursday going into a community, but finding that on the plane that there was a young person going to meet her sibling who was in residential care in this community, yet that whole community is literally her relatives. Why is she continuing in a residential placement as opposed to...
Absolutely.
And why isn't her community being involved and engaged and discussed,
Yeah.
being invited to discuss options around her care?
Yeah.
It's a real life and current issue, and multiply her story. It's everywhere.
Agree.
It's exactly what I was about to say. That's one person that you've bumped into, and there are many children in the same situation. It links to the numbers, it links to the workload, the same as with our case managers. So the scoping you describe absolutely is something we are required to do. When we look at the workload for case managers, it's not happening. What we see is that residential care is considered a safe place because of the numbers of cases the workers are across. The focus is not going into what are the options in terms of family. So that's why we're doing this piece of work to demonstrate that if we lighten the load for workers, give them a referral pathway to do that critical work, it will happen and it will be successful. It's not just finding a bed with a family member or someone of significance and crossing our fingers. It's making sure there's a package around that as well. So any services that are needed for the young person, services in the home, any changes in terms of the home layout to accommodate and make that a placement that will be successful is all arranged at the start. So that's the meaningful scoping. The bit about residential care is as we start to lower that sheer volume of children coming through, the relationships, the assessment and the getting to know the young person comes to the fore, and that means that we are more able to design and scope suitable placements for the young person to thrive in. So residential care for some children may be part of that continuum of moving through the child protection system.
As in being institutionalised or as in therapeutic care?
It should be therapeutic care, but you can't achieve meaningful therapeutic care if you have high numbers of children coming through, high numbers of staff changing, a reliance on casual staff, because so much of the therapeutic engagement is relationships based. So the aim is by reducing the overall numbers of children that are going through residential care, staff will have greater retention, they'll have greater engagement with the young people, and the time spent in residential care should be shorter, because with the more intensive engagement, the pathway to the longer term placement should be more identifiable because we have time to do that. It's the same with the case managers. By bringing those numbers down, the engagement is stronger, and we just see this shift back further up into early intervention instead of this residential blowout, which I was so shocked when I came back to South Australia just to see the numbers. So to me, that is the biggest risk. Yeah, I agree.
And in terms of the staff who are moving through the residential care, if it's called therapeutic care, shouldn't it be that there is some level of therapy to address the traumas? The trauma alone of being removed is one we don't recognise and don't speak about. But student teachers are not skilled and not geared up for intensive, skillful parenting, which is what many of those children in resi care need, isn't it?
Yes.
So why are there not professional people being recruited for people who have those skills in skilled parenting with children with difficult behaviours and senses of not being connected to anybody, rather than reinforcing that in residential care by people who are doing it as a job to pay their rent while they're going through university?
Yeah, I can't speak for past rationale, but our view is multidisciplinary teams are needed, particularly in the homes. It's finding the specialist skill set. For example, it might be a psychologist, and then as you'd be aware, it's not easy to find professionals, and it's how we best utilise that across multiple properties. So one strategy that we look at the moment, which is not in line with what we're talking about, but it could apply the same principle, is when there is a group of houses or a cluster of houses where there are some concerns about some of the presentation or how some of the children are travelling, we have an active shift with some specialists that move around the properties. That's something we could apply to increase that therapeutic response. It also, I think, is incumbent on us that even though the staff may not hold certain qualifications or may be studying something else, that we proactively provide training in therapeutic engagement and responses, and that at all hours, day and night, staff have access to the support to help address a situation where a young person is heightened. Our biggest fear is when children leave the placement, because they are so vulnerable and there are so many risks, and misadventure is something that can be life-changing for our children. So for us, getting that bit right is a priority. I think it's fair to say we're not there. We have a long way to go, but it is a priority in terms of making sure that the staff and that the children at those properties have all of the supports they need for that temporary placement to be as successful as possible.
Thank you. It's 11:40. Would anybody like to have a break for 10 minutes?
I think that would be lovely. I'm only thinking of others.
Yeah, I'm going to make a couple of phone calls too. Okay.
All right, we'll resume at, say, it's 11:41, resume at 12 o'clock?
Yeah, that'd be great.
Okay, we'll resume. Thank you. Can I just ask, in terms of the structure of the organisation that you're both now in the leadership role of, about whether there is or whether there should be an Aboriginal advisory body within that organisation to guide and refer to in terms of policy development, practice development, and moving forward to address the issues that we've looked at today.
Do you want me to respond for that one? So we do have an Aboriginal practice directorate. It's a fairly small part of the organisation. I think in terms of the conversations we had with the statewide Aboriginal staffing group, plus conversations with our external stakeholders, there's an opportunity for us in terms of the review of our structure and how it's connected. There's some conversations about perhaps a more senior Aboriginal practitioner role in the organisation as well, and how that role can actively form part of those escalation and review processes, where I spoke previously about the cultural lens stopping at a certain point and then just the clinical lens continuing, having an Aboriginal principal type practitioner across that space as well. So as Jackie mentioned, whilst we are still relatively new, there's a lot of that structural opportunity for improvement conversations happening at the moment.
So that'll give you your Aboriginal practice focus. What about the more general things in policy development and advice and guiding the organisation with the engagement with the Aboriginal community, with providing the coordination with whole of government initiatives that bring to bear on outcomes for Aboriginal children and young people, whether it be housing, whether it be education, whether it be justice, human services, etc., health. I just wonder what that may look like in your plans with developing this or furthering what you currently have.
That's right, Commissioner. What we committed to is not being reckless in coming into the agency. There was some significant initial changes, Adam's appointment being one of them in regards to that, and then some sort of positioning around some immediacy around what we wanted to look at. I've always held a view, and Adam shares it, in regard to that type of self-determination policy type of senior role that would enable us to really have that particular focus and that lead. Adam's mentioned not only around at the practice level, and I think the work that we're doing to initially map out the governance in regards to the numerous aspects of that role is a part of being able to determine what type of activity and what type of structure and what type of role that might actually be. So, Commissioner, it's not a particular commitment as such, but it is something that is we've made a commitment around what we want to start 2024 like, but we've also as well made commitments that throughout the coming year that there'll probably be some other changes to support and grow the agency in gaps where you've identified one there that we've actually got.
So it might include things as in policy,
Yeah.
development, service development, from an Aboriginal perspective, Aboriginal
Yep.
leadership in regards to
Yep.
all those things
Yep.
that one might expect from an Aboriginal advisory unit within a governmental department.
Yeah.
And even more broadly, I think if we talk about the evolution of the Aboriginal staff network as a body and the relationships at all levels with our external partners and community, that's where I keep coming back to participatory practice. We put the issue or the topic that we want to talk about at the centre and then collaboratively design that. And at the moment, the structure and the way the parts of our organisation are connected doesn't lean into that in a really organic way, but by changing some of those positions in the organisation in terms of the role, the function, what's within the gift of various Aboriginal roles, I think we can really change that. And then at all different levels, our staff will have stronger engagement with the community and bring people to the table to have those conversations. That's the intent. It just changes it addresses the power imbalance that exists. I won't say it fixes it, because you can never fix in terms of the history of the organisation, but it helps us come together in a safer way to work collaboratively with the Aboriginal community at the centre of those conversations and a voice in the room, which I think it would be fair to say government hasn't always been able to do that in the past.
Is there a time limit on that in terms of getting that established?
It's difficult, in my personal opinion, it's difficult to put a time limit when you're talking about a self-determining practice. There's a significant urgency, in my view, for this to occur, but it will need to be at a pace that works for community. So the conversations need to, and they have started, how we formalise that, I think will take place in 2024, not beyond, hopefully in the first half. It depends what else is happening, because South Australia is continuing in terms of the voice conversation. There are other stakeholders we need to work with. So we want to be aligned, not interfering or duplicating or taking over, but absolutely.
But you'd have to concede the department historically has had always a very strong Aboriginal leadership, Aboriginal advisory unit within its structure. I would have to say over the last 8 years that has been diminished significantly, and could bring to bear with the issues that we're seeing in relation to Aboriginal or lack of Aboriginal involvement in decision making, from the policy context right down to the practice level.
Definitely.
I think what you're highlighting there, Commissioner, is in the absence of it, that there is multiple people that would actually consider, that's part of what their role is. And I think what we're determining is actually we find there will be an enormous opportunity and strength of actually having some specific dedicated focus in this particular work, and a commitment around growing Aboriginal leadership as well in regards to that policy focus specifically around that would be. Adam's talked about the practice that we need to do. You've mentioned the policy. I'm thinking about how we have these enormous opportunity with the our commitment around growing our ACOs, our ACOs, engagement with closing the gap and SACON, and we have the peak as well, which will be instrumental in informing and advising the department on areas of concern and identifying areas of where we need to make improvements. So we do need to have somebody, we do need to have a particular position that can be responsive to that.
Thank you. The next issue that I would like to raise with you is the one of family group conferencing. Now, we've spoken a bit about it in the earlier intervention area, but the evidence shows that it works to achieve better outcomes for families, and we've heard that consistently from not only staff from the department but other experts that have given evidence here. And we note that DCP has recently commissioned a report from Paul Nixon, who Paul provided evidence to the inquiry as well, regarding family group conferencing. And that evidence demonstrates an extremely high success rate and overwhelmingly positive outcomes from family group conferencing in every jurisdiction and every area where Paul has worked. And he's a New Zealander, you would know, but he's worked extensively internationally as well. In the case file reviews that we undertook here, it shows that the family group conferencing is not happening in a timely manner or at all in many circumstances. The current legislation states that it should be that the department considers family group conferencing if appropriate. And it's seen by families and the community that that's being used as an excuse not to conduct family group conferencing. Given the proven efficacy of family group conferences, do you consider it's appropriate they're often convened so late in the intervention process or not at all?
So a couple of matters in my response there, Council. First one would be we recognise and absolutely value the insight and evaluation in regards to what Paul Nixon's actually said. In fact, before my commencement, I'd already engaged with Paul in regards to his learnings and his insights into family group conferencing, and we've remained, and he's participated in a number of aspects in providing advice to me and now to Adam in regards to in regard to that matter and other particular reform to sort of ensure that we embed that as well. In regards to the current legislation, in regards to the consideration, again, strong feedback and a theme that came back from the discussions around the amendments to the legislation, that was also highlighted as part of that particular requirement. And then lastly, my own personal view is that I think if we can establish family group conferences as early as possible for our families, for our children, for our communities in regards to that level of participation to safeguard and prevent families becoming more embedded in the Department of Child Protection. That's a view I hold firmly. It's a view that I've shared with Paul, and it's a view that I've got confirmation on in regarding to where we should be heading in the future. And lastly, the only thing I would say as well is I'm not 100% sure because I weren't in the department when the case reviews files that you had. It doesn't surprise me in regards to the lack of family group conferencing in potentially what might have been some case reviews over a matter of number of years prior to where we are now. We know that the investments recently, we know that family group conferencing when it was in the youth court, and then indeed when it's been in the department, and then it was only really the further additional funding more recently in this government that's been that actually has been given by this government. I will say in my conversations as well, I'm always having conversations in treasuring with my colleagues around, family group conferencing going forward. So there is already a signalling in regards to there is evidence to show this works. We do know that if we can bring it further and earlier in our interactions with our families, we do know that we would probably reap the benefits of that.
I'm aware that there is still a capacity within the youth court to conduct family group conferencing, but I've heard that it's not being utilised very often by the department. Do you know why?
I don't know why as yet, but I'd only met Judge Eldridge a couple of weeks ago and she told me that very thing, and forgive me, I can't remember her associate's name, who is it, Michelle? That they were referencing that as well, so I took it upon myself to go away and actually find out what was happening in that. I'm not sure about that historical programme of where that it sits now. I think there is an attempt to try and have a look at that before those particular proceedings, but yeah, that's already on notice from Judge Eldridge on me.
It's been recommended that family group conferences be made mandatory for all children in Aboriginal families at risk of statutory intervention, and that this be a requirement prior to any guardianship application being made to the youth court. Would that be something you would support in that change in legislation?
Again, the first thing I'd probably say, counsel, to that is that I would seek the views and evidence and expertise on that particular matter. I think historically, I often caution when I think about mandatory. We know that in these settings of where you wanting people to come together to collaborate and to speak openly and truthfully and really, in regards to the support that they might need or they might require. I sort of, there's always a level of caution when I think about them having something mandatory in legislation that families, feel obviously they would have to comply. However, I'd also as well see the real benefits of people participating. So I would probably say that I would seek assistance of others to sort of inform that advice to government around if I thought that was necessary, really.
In terms of the requirement or embedding of active efforts, though, wouldn't it be part of the active efforts that the department does actively facilitate and go out of their way rather than just consider and tick in the box that we considered it, we thought no, that be put into place if at all possible? Yeah,
I think the term that you're using there about the active efforts to, and I'm not saying either way at the minute, the direct question that you asked me about mandatory, my response to that, in this particular case, I'm sort of saying that absolutely with active efforts, and I think the skill set of the workforce in regards to the encouragement and participation for families, we do monitor that already now, and the number of people that have been offered family group conferencing to those that participate and engage, and I think that's something that actively, with or without the legislation, we'll be monitoring to see if if we've actively engaged people to participate.
And what will be the outcome if you find that you haven't?
Well, I think it's down to us actually understanding what some of those barriers are for families. So some of that can be as much as where I guess the complexities of family groups and the dynamics of family groups. There might be an opposing view of a family member of their participation alongside others. I think that's just really about our practice and our skill set within our work group to try and speak to both parties to try and have a look at focusing on what the child would be. But I guess it comes back to saying we're currently actively looking at the number of people that are offered and engage, and really leaning in on that from a practice point of view on what we can do to enhance and ensure that we increase that number of participation.
We've heard from the evidence from Relationships Australia that in their implementation of the family group conferencing for Aboriginal families, they recognise that parents who are about to have a child removed from them are possibly not the best ones to be making decisions about who even attends at that, because of their shame, because of their sense of not wanting extended family, but they override that. They will source and find the appropriate people in the kinship network to be making decisions about that child. Is that not something that the department should also be doing?
I'm not sure that we don't. I don't think that that's something. I'd have to take that on notice and come back and reframe that. But I would actively think that if we're participating in family group conferencing, but that we would do that anyway. That we would definitely lean into family members around who's important to that young person or not. Do you have a view on that, Adam?
Yeah, it does. I do have a view. It doesn't sit comfortably with me what you've proposed Brazza are doing. I think it's appropriate. What you say is absolutely right in terms of the shame, the pressure, and what parents might be feeling at that time. I don't feel comfortable with a non-government organisation that's not an ACCO or a department bypassing a significant person and going directly to family. What I would be comfortable with is in partnership with ACCOs exploring options and getting some consent from the parents. I know in conversations, particularly with Aboriginal parents, they talk about how disempowering the process is and how there's no voice, and I just think that's a really live example of us not respectfully engaging, bypassing, looking for someone else. Mm-hmm. In a cultural context, it's absolutely sensible because there are, what's the term that Muriel used at the symposium?
Big auntie.
The big aunties. Like there are culturally appropriate people that should be there, but to me, we have to do that in a respectful way. And what you've described I feel a little bit uncomfortable with just a literal application. I think it's...
And I may be not clear. It's not necessary. It's certainly not in every event, but every instance. But if for instance, the parents are seriously drug affected and just simply not able to make decisions, about themselves and their own care, for instance, that for them to say, no, we're not going to participate in a family group conference, I don't want to be there, is not enough for it not to happen.
Oh, I definitely agree with that. That's absolutely sensible. I do think it's important though that there's an ACCO in the space. For me, that's a critical component. But in terms of that broader conversation about the family group conferencing, we know they're not prohibitively expensive. We know from other jurisdictions and our own learned evidence now that they are beneficial. It's how we build the capacity to have those. I think there are ways to ensure that they are routinely made available, which is what I would like to see the system have. Mandatory or make it a requirement, whatever language is landed on. It's not unreasonable for us to expect that service offering is made available to every Aboriginal family. It's how we position ourselves and build that capacity. Mm-hmm. I think there's findings coming back formally in terms of the instances of family group conferencing that have been funded in this period, and from that we'll be able to say, well, we can see the trajectory change for families, we can see the reduction in harm for children, so let's look at how we can build that capacity, and that's the next conversation. It does also link, of course, to our cultural proficiency because our workforce need to understand the significance of that event as well. Mm-hmm.
So how do you measure, or what does offering look like in terms of family group conferencing, and how do you measure that? What does offering look like?
I think it needs to be multifaceted, and it may not be that the offering comes from the statutory system. It may be the offering comes from a convener or from an ACCO or from a trusted source. We need to do work around communications, around what this option is, because it's about addressing that historical power imbalance, the fear of dealing with the department. It's taking back control of family and family making those decisions. I think in terms of the measuring part, whilst we have data showing us this is how many have elected to participate and these are some of the reasons why family members haven't, the data we need to look at, and I think that's one of those opportunities to partner with the community, is in the instance it wasn't offered, have some really clear criteria why wasn't it, and drill down into what's the reason, because there shouldn't be too many reasons why it would not be offered. I can understand reasons why individuals may not accept, but when you make reference to mandatory, and I sort of go to a requirement, it should be offered because it is a sensible next step and empowering for families. So we need to review where it's not happening and why. I suspect that will lead us to a deficit in training and capacity around understanding culture.
And that's where, not from a cultural perspective, but that's where the engagement with Paul Nixon by the department, where we are engaging his services in regards to working with our regional teams to ensure that they are fully across what family group conferences is, about the referral to services, about the engagement with the families, about the, that sort of discussions that should occur, that consideration by the workforce. So we've got, in regard to training going forward around applying the principles of family group conferencing, discussing family group conferencing, the benefits of family group conferencing, that whole awareness to our staff groups to ensure that those positive interactions sort of occur and those referrals occurred. And, we look at that. That's a big piece of work that Paul's been doing across the agency, starting off at several regional offices for that
And
awareness
again, with the
initiative.
regional offices, it's going to be a difficulty in terms of the capacity, any capacity to do family group conferencing in country areas, isn't it?
Yeah, that's true. It is going to be, but I think that we've only got a number of obviously options available to us at the moment in regard to family group conferencing, and that's certainly something that we want to lean in and get that level of investment, that evidence to support that this is a particular program which is successful, and we want to roll that out across the state.
I'd probably even go as far to challenge, and it is a bit of an assumption, I suppose, that we carry in a metropolitan environment that there wouldn't be capacity, but I genuinely think the most important part of the family group conference convener role is the understanding of culture in the local community, and I would be really confident those people exist in those communities. It's ensuring that we as the system provide the additional training to empower and then establish that local response so that family group conferencing has that local connection and can occur in a timely manner, not waiting for another provider to get on a plane and show up weeks later, having that immediate response. And building that capacity is not an overly difficult process. If there are people willing, then to me that's a really great opportunity to pursue rather than a risk because it's regional. I think there's some benefits there.
And will that be pursued?
I did state yesterday I have strong views on family group conferencing, so in terms of what's within my gift and influence, I will be pursuing that.
Thank you.
And I'm sure Jackie will lean into the space as well.
Thank you. The workshops with your staff identified a potential flaw in the family group conferencing in that the outcomes were not true self-determination for Aboriginal children and families due to the department having the final say for any decisions that are made. It's been noted by the department staff that it would be more appropriate to run conferences in the ACO sector, and less involvement from DCP could result in better outcomes in terms of true self-determination. Do you agree with that assessment?
I've seen that work in other jurisdictions successfully. Our only requirement is the statutory component. So in terms of the family group conference process, that could land with some clear commitments moving forwards, and then the department can test that outcome against the statutory requirements and say, there's not a role for us.
And will that happen?
Of course, there is already that level of investment with AFS in regard to family group conferencing. And I do know that I spoke to multiple ACOs that have actually shared an interest in thinking that there would be a better place to deliver that. And I think we have yet to sort of put a proposal, with our own proposal being in the rolls now around how we facilitate that level of funding going forward.
So
in the
have
future.
you consulted beyond ACCOs, like into Aboriginal communities outside of metropolitan Adelaide? And I'm not talking about statewide services actually fielding a local level ACCO, because they are not.
Yeah. Yeah.
I am wanting to hear from you whether in your deliberations has there been consideration going beyond who you currently fund
Yeah.
and going into Aboriginal communities and seeking that information out?
To be honest, Commissioner, no. And I would say that we haven't embarked on any further programme development to do with family group conferencing, not in regards to, because it isn't our intention to do that, because I think it is. It's just about us actually. We haven't, we want to see the evaluations come through. We want to see, we've been heavily focusing on the legislation and the changes and the amendments that are going to happen there and informing those deliberations. I think that beyond that, it's definitely something that we want to look at, and we clearly and respectfully we would be looking at that localised consultation.
With my visits to some of the regional centres such as Whyalla and Port Lincoln and others, I've been invited to meet with the smaller ACCOs and the board members and have conversations, and there's a clear aspiration to be more active in the space. So whilst those conversations weren't specific to family group conferencing, in the back of my mind I'm thinking this is a really good potential conversation when we get to that point. So we do need to see the assessment. It seems to me jurisdictions like to test something in their jurisdiction and then have findings, and that's I have no doubt that will come back saying this is really something we need to do. But the next step is exactly what you're saying, Commissioner. It's taking the time to sit down in the communities and have the conversations. And I think it's safe to say we're committed to that. But I understand the scepticism, because historically government would go to a large provider and say, can you do this? Give us a statewide, tick the boxes and away you go. And even with the best of intentions, that model will not come anywhere near the model that has that local relationship and resourced appropriately. The outcomes will be significantly better.
Regardless of whether they have a satellite service in that community or not.
Yeah, exactly.
Exactly, yeah.
We've heard from your workforce that there's support for strengthening connections with Aboriginal communities to identify and support appropriate participation in their family group conferencing and the broader family-led decision making. So what steps are being taken to strengthen those connections between the department and the local communities? You said you're going out and sitting down with them. Can you speak to that in terms of how that genuine engagement with the Aboriginal communities is being fostered and being entered into?
Are you comfortable for me to? Yeah. So I think it does link a little bit to the conversation around cultural supervision, because we want this to be at every level. There is, and I'm sure the Commissioner would be aware of this, there is expectation on those of us who are Aboriginal people in very formal government roles to be true to community, true to ourselves and culture. So I'm acutely aware of that every day walking into that building. My expectation of the team, and it's their expectation of the system, is that we are working much more in partnership with community. It's difficult because of our history as an organisation, but I do believe that the messaging and the conversations that we're having with our community stakeholders, notwithstanding the trauma and pain that people have carried, people are starting to see that Aboriginal staff inside the organisation are our aspirations are in line with each other, that we want it to change, we want it to be more empowering for families, we want it to not be just this system that in increasing numbers removes children from Aboriginal families. The bit that we need to establish, and it will take time, is creating that routine process of having conversations, making that a safe space, and for the relationships to develop. We've started setting that platform. I'd even be confident those before us had started some work in that space, but it's a real focus now, having an Aboriginal Deputy CE, to make sure that the connection between the Aboriginal workforce, which are a passionate, strong group of staff, and a higher proportion of the workforce than some of the larger child protection jurisdictions around Australia, to make sure that's in line and co-supporting the voice from community. I think the strength for culture is something both of the cohorts need, us and our community stakeholders, because it is such an overpowering system. It has so much history and trauma that without working together, you very quickly run out of energy and it becomes overwhelming. So I see the significance of it. I'm satisfied the majority of our Aboriginal staff see that as well. It's about making sure we have that respectful engagement with the community and work together in reclaiming some power and authority in the space.
Right. Thank you. Have we got any further questions with respect to participation?
I've heard from many Aboriginal children about their experiences, and one of those have been about their voice being heard and not being afforded their own participation in decision making about their own care, often in the context of family group conferencing. And are you aware of the concerns being raised by Aboriginal children and young people about their lack of engagement in their own decision making, about things that directly affect them?
Commissioner, as you do, I also reflect on conversations that I have with children and young people, and that I mean, there's many things that they'll tell me about the system, and that's the beauty of engaging with children and young people, because they will tell you if they think that you're going to listen, they will tell you around their experiences, and absolutely, I think that is something that they will talk about, not being heard as part of that, or not knowing what was going to happen to them. And I think that that's resonated really strongly with me in regards to moving forward and what we need to do about their participation in this, because it is about them. It is about them. We have to hear that voice. We have to allow that voice to be heard. And if it's silent, we've got to go again, because it will be. I don't think I've met many young people who want to have a particular say around how they're treated and how they feel that the system and that they're engaging with and is there to support them is performing. And I think we just need to listen more.
We also underestimate, I think, children. We make assumptions based on their trauma, and you think, oh, that poor child, they've been through so much. Let's not add to that. Let's not do this. But
that's what I often hear from practitioners.
Yeah.
Their explanation as to why a child has been excluded from a decision-making process.
Yeah, and you think it's just such a false assumption. The fact that those children have come through such trauma, and in many cases achieving things that are important to them, it's a missed opportunity. And I think,
but it's also their right.
Absolutely,
Right.
But I think to a case that was brought to the Commissioner's attention recently, and it was some young children, and the Commissioner rightly said, what is the voice of the young person in this? And it took some time for me to bring the internal stakeholders on that journey to actually have the conversation with the children. And it got to the point where I intervened directly and had a conversation, and the children were articulate. They were very thought out in terms of what their voice was, and it was clear and consistent. And we were able to say, there's what the children have said, and then for us to respond in terms of delivering on that.
I tell the children, when I engage with children or young people, I tell them that I have to be accountable to them, that they should hold me to account, that they, absolutely, that we should as a system. It's not the other way around, and also as well the just how deeply. When that was said to me actually by an Aboriginal young woman, how deeply that I took that is that she recently came and shadowed Adam and I for the day, because we were just generally talking about how that accountability occurs and what sort of happens. And I said, I've got to be honest, because she was saying to me, you won't come here again, you won't listen to us again. And I said to her, I absolutely will. You can absolutely hold me to account. You should hold me to account to what this is. And I just said, I'll go beyond that. Why don't you come into my world and just see what I do? You are why we're all here. This is what we're all doing it for. I think we've had 2 so far. Many others sort of wanted to come along as well, but just to sort of, it's not everything, but it just demonstrates to them that we do intend to do what we said we're going to do.
In terms of accountability and explaining to children the situation that they find themselves in, it's a practice in the youth court for the Crown solicitors to seek to waive the requirement for service of any documents on the children. And what's put forward regularly is that children shouldn't know about it's too traumatic to know why they've been removed and what the history of their parental inability to care for them is. It flies in the face of children being able to understand. And then later in life to have that sense that they were not lovable enough, that they were at fault, that something was wrong. Is that something that needs to be changed in terms of a practice within the court jurisdiction when we get to that situation?
There's an opportunity in terms of when we look at, I agree some of the content is not age appropriate, and I would say it would be really inappropriate for us to give verbatim some information, but in the same way that we target communication around other topics so that children receive a message that is age appropriate and they're informed and they feel part of the process, that is something that in theory could happen in that space. The summary could be updated so that it's more child safe, rather than just completely precluding the young person. But no, I think that's a really good point, and it is something that could have some traction. But again, that's a conversation we'd have to have with partner stakeholders.
And again, I'm going to give my opinion, and Council Commissioner, I'm not a clinician, so I just put that out there. I'm not a clinician, also, and I'm very respectful of the profession. However, I hold a view that, building on what Adam said about aged appropriate, but I also hold a view as well that I think it's important that children have that connection to family, to culture and to community. So what resonates with children in regards to their framing of, the events and what's happened can be minimised, and they can receive that through other different sort of sense still of belonging, sense of love, sense of a family, sense of a culture and a community. And I think that really, the documentation that you're referring to there may be strong evidence. There may be people who are more clinically qualified than I. I think what sits with me is what resonated when you were saying about how that child feels about that. And I think there is things that we should be striving for all the time, that goes back to the Commissioner's point of view. It is a right of a child to actually have that connection. It's their right. So I think that's where I sort of feel in some of those particular
It could even be conversational in terms of the information sharing and the connection to what's happening around them, but with safety at the centre for the young person.
Because one of the things I would wish to raise, coming from the perspective of children and young people, is that whilst their voice is really important, that their right to family is equally important, and that sometimes they don't know who the rest of their family is other than their parents, and particularly when they're really, really young. My question then to you is, and it goes back to the point around offering family group conferencing versus mandatory. In the previous legislation, it talked not necessarily about family group conferencing, but about consultation. There must be consultation with an Aboriginal organisation, gazetted. So there is ample opportunity in processes to engage with family and to have the family at the table for the benefit of the Aboriginal child. Is the current practice of the department and the way it manages family group conferencing, not for those who they outsource contracts to, whether it be Relationships Australia, SA, but for your own departmental family group conferencing? Because is that still happening? Is the department still running its own family group conferencing, or has there been a decision to only go to a third party to be the convener of a family group conference?
I don't know that there's been a decision to stop family group conferencing internally, but I think it does link back to the conversation about capacity and prioritising and quarantining resources. So, as you know, I'm of the view these are the way forward to ensure that they happen, even if they are something that should, with workload, it's not always happening. So we need to prioritise it and take the workload issue out of the equation to make sure that it occurs. I don't know if there has been a change. I don't know if you've been made aware of a change.
No, I'm not aware of a change, and I do know it is happening in more regional areas. So I do know that our staff are still undertaking family group conferencing in those more regional areas.
And so my question to you in relation to the first part of my, statement, are your staff, skilled enough to run an effective family group conference, particularly take into account the issues that we've heard about engaging with the Aboriginal community and with the Aboriginal families to know who to bring to the table, rightfully for the child and their right to their family to be involved in a participatory decision-making process?
Yeah. I can answer a couple of those, Commissioner. First is, I think there is opportunities for improvements there. I think it would be remiss of me not to sort of say that there is opportunities of where our staff could be more skilled at that. I think we've demonstrated in the last day and a half that there is some proficiency, more cultural proficiency training that's needed to happen across the whole of the workforce. I think from a probably secondary, and please bring me back on track if I go off track here, but it was just resonating me with when you were articulating about our engagement with families and what we do. A strong sense of what Adam and I, since I've come here, is about taking our children back to their communities, back to country, really expanding that type of right, cultural right and connection, and the right that they have to their family. And that was born out of listening to a staff group tell me about a young person that was in residential care, and they took them back to country. And her words to me was, I didn't see him for 2 days because he was just off with family. He was just with family every day, a new family that I'd not met before, or coming to see him, blah, blah, blah. Which was, so firstly, I want to do more of that. Secondly, what came to my mind, and that I've positioned the organisation, is to tell me, why is that young person not with family then? So you're telling me that for days, and, while you've had this visit back to country, why aren't they with family? You've articulated that this family was around it. But at that, so sorry, I didn't mean to digress from your particular, but as soon as you started talking about connection with family, these types of steer that we need to bring the agency back in line with, sort of saying that is not a nice to have, going back to visit family. It's a right, and we have to. It is our requirement to fulfil that right of that child. So we've already started to sort of say this needs to happen. These need to happen.
And just one more question from me in relation to that. Are your staff skilled to be able to ask the question, age appropriate, in regards to where children want to live or feel where they should live when they're being consulted about their own care arrangements?
I'm happy to respond to that one. I think our workers would say they are clinically qualified to ask the question, but in terms of the cultural overlay, in terms of the significance of connection to family, to country, I would say that's an area that needs the development, because with a purely clinical lens, the response would be different to a clinical and cultural lens. And for Aboriginal children, the cultural component of that question is significant, and in many cases will be quite different to the standard clinical yes/no, because there are so many layers when you think about the primary attachment and definition of family, etc. So I couldn't say that we've got that right. I think that's the stuff we need to focus on.
And when you're referring to clinically qualified, are you referring to those who might be a psychologist or those who might be a social worker?
Yeah, primarily, yes. Because in terms of the...
Primarily social worker or primarily psychologist?
allied health professionals broadly, yeah. Yeah. I think those conversations or those decisions generally involve those two allied health professionals. However, again, as the organisation becomes more culturally proficient, the voice of Aboriginal family practitioners, of principal Aboriginal consultants, this is the multidisciplinary response for a family. That's where they should be having the fore as the expert on culture in that space, which will change, or at least very strongly influence the outcome of what the placement looks like.
Mm. The reason I asked the question, as I've heard from families throughout the Aboriginal community engagement process, and having heard from Aboriginal children and young people, that often the question is approached in a very simplistic way, with where do you want to live, and depending on the child's context that day, on their age, their cognitive development, all those sorts of things aren't taken into account. It's just the way in which the stories have unfolded have been around a very simplistic approach to that question being asked and not done in the appropriate way.
And when you think about the significance of potential impact in just that one seemingly simple conversation, what that can mean for a child, it's a very significant change in trajectory, because it can be a profound life-changing decision.
It's a critical decision-making process that is approached in a very simplistic way with huge impact on the trajectory for the Aboriginal child.
I would
Often when there's a non-Aboriginal care context.
Yeah. I would say there are staff in the organisation who are very good at that, but I wouldn't say across the board that we've got that right. That is something that needs to be a priority, and it links very much with the cultural focus for the organisation.
Moving on to placement. It's the departmental policy to run child protection history checks for any proposed carers. Given the issues already identified regarding notification records, which can be inaccurate and malicious, and that Aboriginal families are significantly more likely to have been notified to the department than non-Aboriginal families, does it not follow that this requirement disadvantages Aboriginal carers as compared to non-Aboriginal carers?
You happy for me to speak to that one? This is something I've shown a keen interest in, and I've spoken with the Commissioner about my concerns. Yes, it does. It also limits potential kinship carers for young people. There may be historical offences, even not related to what we store in our own database, that preclude potentially very suitable and committed carers, while a child could be sitting in residential care. And we aim through the initiative at the moment to demonstrate there are children there who could be with a person who is completely suitable, but for a statutory reason in our legislation or within a policy underneath that they're precluded from doing that. So there's two parts to this, or three in theory. One is the role of our information that's on C3 or our database, how that is assessed in partnership with what comes from police records, and how a decision is made whether that person can be a carer or not in a efficient way in a short time frame. If we look at other jurisdictions, and I think, Commissioner, you've made reference to one jurisdiction in Queensland, but even in the Victorian jurisdiction, if there is an adverse finding as part of that process to be accredited to provide care, the delegations are much lower in terms of who can say, yep, I see that, it doesn't apply in this instance. It could be something from when the person was a teenager and it was fines or a licensing issue. It's not relevant, and that process is very quick because it's a check of all of the evidence, and at the appropriate delegation it's moved on and the placement continues. Here it sits at the ministerial level, and that creates quite a process in itself. So there's two parts that I see as both an opportunity and priority for us. One is to streamline our process now in the current context. The other is to look at opportunities for either legislative amendment or, if there are provisions in the legislation, for delegation to be pushed down from a minister level into a department. They are two opportunities that I think could have really positive benefits for community, particularly for Aboriginal children in having access to an Aboriginal carer that's suitable. And at the moment, that's not always possible because of that issue.
And the same applies to the disproportionate representation in the criminal justice system, as you say, the historical criminal proceedings that may have nothing to do with care or the potential to care preclude Aboriginal families from being carers.
I can give you a rough figure from my role in another jurisdiction, sitting as an executive director there. And I would approve probably, and it wasn't just Aboriginal carers, but obviously you would see Aboriginal carers overrepresented in these approvals. I would waive the
Employment.
well, there's the tool is the adverse finding. I can set that aside and approve, and that's at the ED level. I would do between 5 and 6 of those every week. And those are placements that in South Australia we might not access because of the process difference. So,
and that could have prevented a whole range of kids ending up prevented ending up in non-Aboriginal care.
That's right.
My aspect there is that we do that for employment decisions at the minute now, but we don't do it for caring decisions. We have an opportunity to be able to do
So there is a systemic issue that you've just identified.
Indeed, we have.
So is the department addressing that systemic issue?
We're definitely taking action, and we've partnered with our colleagues in Department of Human Services who manage the screening unit for the process. Both ministers have been briefed, and everyone is across the issue looking for a way forward.
Good, thank you. The DCP practice manual states that the caseworker should, where reasonably practicable, obtain written consent from the proposed temporary carer and adult household members for the checks that are done, the child protection history check and the criminal history check. When written consent is not able to be obtained, then workers should first obtain a verbal consent. We've heard evidence that those checks are undertaken without any consent and without even any knowledge. Can you understand that Aboriginal people might see those checks as a means of the department screening them out rather than screening them in?
Yes.
And when Aboriginal family or kin are not approved as carers because of those decisions, they are not told of why the decision. There's no consultation with the family about. They're just told they're not appropriate, and they're not engaged any further. They're not given a right of reply. Is that appropriate? What
you're describing is not appropriate, but I'm also not sure that's how the process works. So my understanding is if someone is precluded...
So it's not a mandatory process to do police checks?
Yeah, but as part of the process, because the department, as in child protection, has sort of the arm's length arrangement where human services do the screening. My understanding of the process is the applicant goes through that, and if they are precluded, or if the screening unit decides that they're going to recommend the person be precluded as a carer, that they are sent a letter and given a reply period of 21 days to come back with it's the natural justice principle. So if what you're saying is occurring, I'd be really interested to look closer at that, because I've watched a couple just go through that I've had an interest in for the same reason. They were historical, unrelated matters, and I wanted to see how that experience was for the Aboriginal carer. But the screening unit wrote back and said, based on these historical matters, we intend to prohibit you. You now have X amount of days, and that allowed us to put letters of support and put a response. So I'm not questioning the information provided. I'm just interested to learn more, and I'm happy to look into that.
But that's particularly in reference to emergency section 77 removals, unapproved carers.
I think that
Using the police checks to actually exclude rather than include relative carers.
I think that may be where, Council, I'm thinking, Adam, might be that, in the fullness of the discussion,
certainly.
I was just thinking, I was wondering if you were referring to the carer assessments rather than the actual screening of the police checks, that throughout the carer assessment process that they're precluded because of police check information that they've got. We can definitely take that on notice and have a...
Because those two processes are interdependent. And I
Yeah.
think what the Commissioner's just referred to is those emergency placements where our staff might just do a police check, then not provide any context back, because under the Act we can place with people before this
Yes.
formal
Yes.
process.
Yes.
And I think, Commissioner, you're saying that this might be relating to where families have nominated to be the carer for this emergency situation. We've done a police check, not said anything to the family, and gone back and said no with no context. That's definitely not okay from our perspective as leaders of the organisation. If people are willing to put their hands up to say, I'll be a carer in an emergency situation, the very least we can do is go through that process with them together and have a conversation and a right of reply.
Well, I can tell you I've been an emergency carer for a relative, an infant, and I had a police check done on me. As a Commissioner for Aboriginal Children and Young People, what was the purpose of conducting the police check?
I don't know that we could get away from the due diligence component, and I've had a police check myself, but for me I think it's about...
But yours is as an employee of the organisation.
And
This is about a carer, which is the point you raised before.
Yeah, I think it's...
But the
Yeah.
process part for me is how we communicate and engage with people. I would actually defend the police check decision for a child. I think our society would expect that the system do due diligence to make sure the information that may be available is considered. But the process in which we use that information, it should be in a respectful partnership with the person that's put their hand up to provide care. So in your situation, Commissioner, the conversation should have been, these are the steps that we go through, and we do that in a respectful partnership, not, as you've described, Council, where people hear nothing until they're told no and there's no right of reply. That's problematic.
Thank you.
It is also as well, sorry, I don't need to keep adding, but it's also as well something that the work that we're doing around getting more children back to family, and then when we think about, so this is currently a resident care, and if we think about then, and it is our intent to sort of have a look at preventing young people and children even entering residential care, that should be our primary goal. To enable us to be successful at that, we have to look at our placement and our and all those decisions that are made as part of that. It's absolutely fundamental that we have to, we should go back and just really understand. As you said, there may be very genuine reasons why it is. A, either we need to communicate that, but B, also as well, where's, who makes those decisions around that, and how we look at any barriers and systemic issues that are actually preventing from those young people going into the family. That should be really where we put our focus as well.
Additional issues have been raised about approval for kinship carers, as well as any other significant others or frequent visitors. The section of the policy refers to the assessments of DCP, child protection history, or unmanageable risk. What does unmanageable risk mean in terms of excluding people from the household if children are placed with a carer?
So it's come. Are you happy for me to?
Yeah, sorry, I didn't catch the question entirely.
Sorry.
Councillor, sorry.
Part of in improving kinship carers, one of the policy things states that there has to be an assessment of child protection history for frequent visitors to the house, as well as household members and anyone who will be in a supervisory role with the child, and an assessment of whether there's an unmanageable risk with respect to those people before they're excluded from the household. What's the definition of unmanageable risk in those sort of services with a frequent visitor to the household?
So when we use terms like unmanageable, and obviously we want the household environment to be as normal and least institutionalised as possible, despite our involvement. Unmanageable risk is when there are too many variables that are outside of the control of the person or the department when it comes to the protective factors that we need to see in the home. So it may be that we have a care arrangement with someone who is a good carer, is protective, the children are thriving, but someone routinely comes to the property substance affected and disrupts that safety. That's probably one of the more common issues. If there is a way for us to, in partnership, manage the risk, it becomes, it's identified as a manageable risk. It's unmanageable when there are too many factors that can't be addressed safely. In a cultural
Who makes that assessment?
The assessment's left with the allocated workers, and they will reach out to their supervisor or senior prac. But in a cultural sense, when you don't have that cultural knowledge at that level in your day-to-day practice and you focus purely on the established risk matrix and your clinical expertise, seeing a house from a street with a number of cars parked and a lot of people walking around could be interpreted as a risk factor, when in fact it's something we should celebrate in many ways in a cultural setting.
But that's a racist cultural bias.
Absolutely. So once we afford our practitioners the understanding of what the dynamics in a cultural sense mean, having that environment for a young person, it is actually a huge strength, and there are a series of role models, and there's just so much to draw from that. We'll see a shift in the perception of what that risk means. So the actual principle is quite sound in terms of its intent. It's our application that we're going on that journey with our practitioners on.
So who writes these risk tools? Who creates them?
There's the...
In order to understand whether it's a unmanageable or manageable risk, who writes? Where does what's the reference point, and who writes these reference points, like assessment tools, etc.?
So we have a Quality and Practice Directorate that looks after all of the policies, so the interpretations of the legislation, how we operationalise that. In that, there are a number of practitioners with different clinical lenses. What we aim to do is increase the cultural lens into that space. So as we refresh and go through the various policies and frameworks that we have, we aim to introduce more and more cultural content to help people understand, coming into the space, how we operate and what risk looks like. If we have the information that staff source from there in partnership with the training experience and the cultural immersion, I think you'll see much more sensible, rounded decisions when it comes to assessing those risks.
We've heard from Dr. Tracy Westerman, who's an expert in this particular space, who talks about actually a rewrite of variety of assessment tools from the standpoint of a cultural context, because just adding to something that is already franchised in a very systemically racist context doesn't make the improvement.
And I think I referenced yesterday too was about the current, we only have that one current validated tool, and I absolutely, Commissioner, respectfully think that there is a requirement for us to look at those particular
Yeah.
schools, and that has been not my voice, but that has been the voice of community and Aboriginal staff members. Yeah.
Just leading on from that, the exclusion of some frequent visitors to the household can be problematic in Aboriginal families where the family within that household, particularly if they're grandparents or kin, are the very ones that a parent who has child protection issues relies on them for the support, particularly in South Australia now where housing is just critical. Critical. And so the only place these people would have to be not be homeless is to go into that household, and they're then determined to be at risk and excluded. If that's the parent of the child you've removed, they're then homeless. Their chance of addressing the issues that have been identified, particularly if they're drug and alcohol issues or their domestic violence issues, where do they go? And how does that address helping them to address the child protection issues and become capable of taking that child back into their care?
And we've adopted a healthy risk appetite in that space, because I agree there needs to be self-determining factors, particularly if you have a strong carer that you know will be protective of the child, and in partnership and with support available on demand, can call and ramp up as needed. We've applied in at least 2 cases very recently where we've put a separate dwelling at the property.
Right.
It's met our legislative requirement, it's met the requirements of safety, but it's maintained the connection and the self-determining approach. I think the flexibility around what accommodation is and what our perception of accommodation is evolving in line with the requirements of the housing crisis. But in this instance, the response in both of the cases was there is an issue that in the system identifies that this person, under our current rules, can't reside in the property. However, we've been able to identify an option where there are clear safety plans that have been signed and the contact with the main house is clearly outlined, but there's still a connection.
Right.
That little person knows Dad's outside, Dad's not somewhere unknown, and we're working with them. So they're examples of where I hope we're demonstrating the department is starting to make a shift in that direction.
And also it lends itself to that conversation that we were having earlier around the whole of government. So this is about, we cannot, although it is paramount, the best interest of the child, but this is in the best interest of the child. This is about having the right supports for family members. So the whole thing about child protection and family supports is to ensure that we start trying to work across government around what can we do, what supports do we need to have for people that are significant to these young people, to actually make sure that they are safe and that they, but also as well that supports are made available to these, like parents, things like that, to try and not just sort of say, well, we've got our eye on the child and that's fine. It's about what's in the best interest of that child, and that's to have those relationships with those significant people to them.
Thank you. There's also issues that have been raised around the timeliness and the effectiveness of family scoping, and it appears that in practice it's either happening too late or without input from Aboriginal family and community. DCP staff have commented in their workshops that the current mechanisms for family scoping is inadequate. Can you comment on that?
Are you happy to, I'm happy to turn around and say I think absolutely, I think there isn't enough, and I do think that it is at a later stage, and I do think when we are relying on people that are part of the system or being faced by the trauma of removal of children, and we're asking those very same people around the identification of people around that child, is insufficient, because I think that they're processing the trauma, they're processing the events that are occurring there and then. So I think the way that we want to expand that and work on that even more would be speaks to the heart of what you've been coming through and saying in regard to family finding.
It does, and it's in response to the voice of our staff in terms of they're saying to me, I don't like going home knowing I haven't done everything I could for a child or for a family. And the family scoping came up time and time again as the number one thing, because they know the alternative is a series of foster placements and potentially residential care. So they very much want more of this, but we've been able to identify, due to the sheer volume and the high-risk nature, particularly in the investigation part of the child protection system, that this important function, they're two incompatible priorities to sit side by side. When it's the emergency response going out to assess the unknown, it will always take priority in that context. So in order for this critical task to occur, we've had to separate that.
Well, it used to be a function that belonged and sat in the Aboriginal community until the state made a decision back in 1997 to remove that.
And I think part of this learning that we're on is looking back and saying what did happen in the past, because what we're doing now is clearly not hitting the mark. We're seeing growth in the wrong part of the system and bad outcomes for kids and families. The activity that we've just started, and I acknowledge I should have been more thorough in my research before kicking off, but I think very quickly we'll start to identify through all of those stakeholders what were the things that have worked better in the past. And I agree, the department or welfare should not be automatically the people going looking for family.
Government doesn't know our families like our Aboriginal communities
Exactly
do.
right. Yeah.
Government is not best placed to find families like the Aboriginal community does.
So I'm really hopeful and confident that we'll be able to pick up on the best practice from what you described, Commissioner, and we come up with something co-designed that draws on that experience and that model in the same way, not just in terms of the experience of people that we're here to serve, but also in terms of the community and its involvement, ownership and autonomy in that space. That's our intent.
Thank you. Placement decisions are being made prior to any consultation with the ratio, and then appear from the case analysis that we've looked at, they're not revisited. I think we mentioned yesterday that often the consultation with the PAC and their ratio appears to be a tick in the box process rather than an actual genuine consultation. How can this be addressed?
So it is very much linked to the family scoping issue, and even if you go as far downstream in terms of annual reviews, the focus and the missed opportunity each time we do the tick and flick on that, it just means that history will continue to repeat in terms of the trajectory for the child. The bit that we are demonstrating with this initiative is that for the important and critical tasks, we need to take that workload away from the staff. So I'm confident in terms of what you've described, we'll start to see by quarantining and setting up a process, the revisiting of the placement. So where we were talking before about a young person might be in residential care for a number of years, there would be those routine revisits of the conversation. I like to think that there are monthly care team meetings for each child in care. Now, I can't say that there are at the moment, but I'd like for that to be somewhere that we're at. And each month I would like us to have a conversation about the placement. Where is the family scoping team up to? Have we thought about, and I'm hoping to get to a conversation about cultural support plans. I think that's something that should feature in that monthly conversation as well. So there are a number of things where once we create the capacity in the system, we can implement some of those must-dos.
Right.
And the frequency, and that will address exactly the issue you've described.
Thank you. There's also issues that have been raised around the compliance with the placement hierarchy, with children being placed with what the department has determined to be kinship carers, and then that being deemed as compliant even if those carers are non-Aboriginal or are not recognised according to the Aboriginal culture and kinship rules themselves. Also considered to be compliant if the child is placed in residential care run by an ACO, which doesn't guarantee that there's any cultural connection at all. do you consider that the current practice is in keeping with the true intent of the Aboriginal Torres Strait Islander child placement process and being applied to the standard of active efforts?
So I don't. In terms of the conversations that we're having in that space, and I'm sorry, Council, can you just repeat the last 2 dot points for me?
Sorry. The placement decisions are being made without any consultation and they're not revisited.
Yeah.
And the hierarchy is not being complied with. Their children are placed with what the department determines to be kinship placements, but they're not necessarily under what the Aboriginal community would decide was kinship. And that's then deemed to be compliant, even if they're non-Aboriginal people they're placed with. If a child is placed in residential care run by an ACO, that's also considered to be compliant, whereas there's not necessarily any cultural connection whatsoever, or the cultural connection consists of being taken to a NAIDOC festival once a year.
It resonated when you said it, because this is something that the PACs have raised with me, as well as our Aboriginal family practitioners. So what they're saying is they themselves have been vocal in this space but not felt heard in terms of the case direction. So it links very much to that bigger picture about positioning and the voice of both our Aboriginal staff but also the community. What's missing for me in the current process is the oversight. So who says it's okay that that's a equivalent of a kinship placement because an ACO runs a resi? Who's reviewing this? Who's oversighting that? And that's part of our review process that doesn't exist yet, but that we are wanting to build.
I bet you it is an Aboriginal people.
Pardon?
I bet you it is an Aboriginal people that's deciding that.
Yeah, I think you could be right. And it's a very broad interpretation, regardless of who's applying that. But that's come to be, and the Aboriginal staff have told me that's come to be purely because there's just been no governance over the compliance with that.
And is that coming?
Yes.
Right.
Oh, absolutely.
And I don't know. Again, as part of the discussion, I'm not aware, Council, that placing Aboriginal children in residential care under the management of an ACO was part of that came into our statistics. So that's something new. If you're saying that's what the staff group are saying, is something that I'd really like to take on notice, because that to me is not that's not principally something that would go towards our target. So I need to have a look at that.
Yes, we've heard that, particularly in reference to the ratio placement.
Yeah. Wow. Okay. I'll take. Thank you. I'll take that. We'll take that on notice as well.
As they have multiple residential care
They do
units across South Australia.
And of course, I'm thinking about our current target. And if you're saying that's included in that, I'd like to just have a look at that. Yeah.
But I think the Commissioner was also making reference that, or it might have been yourself, Council, sorry, that even though the facility is Aboriginal governance applied to that, the actual experience of an Aboriginal child in there, they may not see an Aboriginal worker on every shift. There are...
There's no connection to culture. There were also issues raised around the Winningay assessment tool. The policy states that it must be used for any Aboriginal carers or carers of Aboriginal children. The question is around delayed identification of Aboriginal children. If they're not identified at the intake point as Aboriginal, the assessment, it appears the assessment of carers is not revisited using the Winningay tool. So, and additionally, are there any Winningay assessments undertaken by Aboriginal staff when they're being done, or is it just a general application of the tool?
If I can, you might be able to answer the assessment process and more procedural aspect of it. But just to go back to the identification one, obviously as part of the Aboriginal children child placement principles. Clearly some of me educating myself about the meaning behind that, and interestingly the identification one, and when I sought counsel to other people about how, and what we do, and the identification one being at the centre of what we do, and it's really resonated with me and broader in conversation with our Aboriginal practice director in regard to that identification has to be the first one. So it has to be the first one for us to actually ensure that we've identified that. And one of the reasons why it has to be is because it appears that we don't then, it appears that our practice of going back and applying maybe some of the early aspects of the placement principles don't get revisited. Now, the practice directorate assured me in the manual of practice that that's what actually would determine. But again, I think that I've heard evidence, as you have, in regards to when identification hasn't occurred, then, some of the decisions that were made for those young people are not revisited. But in regards to the utilisation of the tool, I don't know if that's Aboriginal staff who actually administrate that tool and complete that tool, or if it's just all staff.
I don't know that it's Aboriginal staff that are administering. I do know the tools.
It's part of the case planning process.
Yeah.
And it's usually the practitioner. The question I have is, who gets to do the cultural accountability of the cultural identity support tool?
Yeah.
And you've got the data
Yeah.
from the department that
Yeah.
speaks of many being put in place.
Now, it's up there at 90-something%.
But who
now,
does the
isn't it?
cultural overlay of assessing whether those cultural identity support tools are in fact culturally appropriate? Are they what the child actually needs? Are they really enabling the child to maintain a connection to family and to community and culture, to uphold their cultural identity? Who gets to do that?
I don't know the direct response, Commissioner. All I can tell you is, in my questioning to our Director of Aboriginal Services, they've been pretty clear to me about an absolute asserted effort in regards to that and those particular plans. And you see yourself, you look at the data trends of going from quite a low base to now it being a significant aspect and process of that particular planning stage. I'd have to take it on notice around, how's that used or not. I guess I guess respectfully, I just took some comfort in our Director of Aboriginal Services being supportive of the efforts that we've made in that particular direction. But I can take on notice specifically who's up. Do you know anything about that?
No, I think it would be good to take on notice. But when you were describing the late identification, I'm just trying to think of the client experience in that process. What I suspect is that there's not identification and a foster placement has occurred. Once the identification occurs, that our efforts are not focused on the tool and then looking for kin, but instead saying, well, there's maybe some attachment here, just leave things and let that play out. That's what I suspect.
That's what we're hearing.
Yeah, that's what I thought
very much
it might
what we're
be.
hearing.
Yeah.
With that Western idea of what attachment is.
Yeah.
Being overlaid. It's 2 minutes. It's almost 1:30, and I'm aware that you need to be away by 3.
Yeah.
Today.
I was just going to say, Council, I just wanted to make sure.
Sure.
Yeah,
No, I
yeah,
haven't
yeah,
forgotten that.
yeah.
Could we, Commissioner? Would you be happy if we just have a half-hour break for lunch and come back, because there's probably an hour.
Yes, it's lunchtime.
Work. We'll restart. Looking now at the attachment and permanency planning. After the changes to the legislation in 2017, there's been a greater emphasis on timely decision making, which means that long-term guardianship orders are being sought earlier and earlier by the department. This is borne out by the data and the evidence from Better Start, which shows that there's a dramatic increase in Aboriginal children being placed on long-term orders before the age of 1 year as compared to a decade ago. How do you explain those trends, given the commitment to reducing the overrepresentation of Aboriginal children in the child protection system?
Happy for me to speak to that one. So there are concerning trends there, but at the same time I would not want to recommend a blanket implementation of extending timeframes. So in terms of the process being sped up or quicker in certain cases, I would only be supportive of that in terms of the views of the biological family and the Aboriginal kinship option being something that is mutually agreed upon. If all parties are of the view, and where applicable the child's voice as well, that this is the best long-term stable option for the young person, I would be questioning the value in why you would make that process longer. If the long-term placement was not mutually agreed by all parties, I think that's when we have to apply really careful due diligence, particularly if that long-term placement is being recommended with a non-Aboriginal carer. I think linking back again to our understanding and cultural proficiency in the organisation, our staff with the best of intentions are following a process which could in many cases, and history has given us plenty of evidence to support this argument, create permanent disconnection both from culture, from kin, from country, but more importantly from important family connections. For me, I've leaned into the space because this was the highest risk example that I could see where when parties don't agree, the cultural lens in the escalation and review cuts out at an inappropriately low level. So our efforts have been to look at the scope of this situation. There are children that are in the system now where the harm or damage in terms of connection culturally has occurred, and they have developed a primary attachment to a non-Aboriginal carer. And there is one matter where, against every fibre in my being, I was left with no option but to support the continuation of that process.
On what grounds?
So much damage had been done in terms of the voice of the family, the way that the biological mum was engaged with, the trauma that not only mum carried but has been increased by the experience going through the system, the escalation processes that had happened in the past. Mum is completely disengaged and overwhelmed and severely traumatised and hurt by the process. The problem for the young person is the way that the system handled their child protection matters. Their connection to culture has for them become a trigger, which is the opposite of what culture should be. Culture is a strength and is something that should be celebrated, but it is triggering for the young person. They've had such a severance of their relationship with culture for so long, and we're talking years now, not months, that their only known person of security is this non-Aboriginal carer. Looking at that and looking at the trajectory back, just embedded in me the urgency that this can't happen. There can't be more children where the lead up to the conversation about long-term guardianship is the decaying of the connection to family, to culture and to community. So for me, it's all the way back here we need to start. Otherwise, similarly to what we've seen in the residential care space, in 6, 12, 18 months, we'll see a series of Aboriginal children that have very limited, if any, connection to their family and to culture because of the way the system has engineered the process. So it's pulling that whole thing apart right back to the very beginning and ensuring that the Aboriginal voice is part of every step of the escalation all the way to the very top of that process.
So what will the department do to actually reverse that? If there are long-term guardianship orders that are being sought out earlier than what was seen a decade ago, and we see the severance or the severing of relationship of an Aboriginal child when they're non-Aboriginal care to their family, to their cultural identity, to their community, etc., what will the department be doing to address that?
So the delegation for the long-term guardianship process sits in our roles. So I'm hoping that from our evidence today and yesterday that, Commissioner, you do get a sense of what our priorities and values are in this space. My commitment is that I won't support or endorse a long-term guardianship order if I can't see culturally appropriate due diligence at every step of the way. And I completely respect the anxiety and distress that the process causes non-Aboriginal carers, but I respectfully remind our carers that this is about the child, and if the child is Aboriginal, their connection to culture must take priority over the wishes to have that stability in the carer household, and that has to be demonstrated. I'm hoping that we will have, with the cultural awareness, with the immersion and all of our strategies around the voice of our staff partnering with communities, that this move back here to proper engagement will occur. But in the interim, there are going to be cases that are coming through where some of those previous practices have applied, where it will come to us, and my commitment is that I won't endorse a long-term guardianship order for an Aboriginal child in a non-Aboriginal placement unless there is clear support from the biological family or thorough due diligence. And it's not department due diligence, it's the community due diligence. We've spoken with extended family, we've spoken with the ACOs, we've spoken with everyone relevant to that young person's connection to culture, and then make that decision. Previously, what you will have seen is a narrative that says this is the primary attachment. We've arranged connection to culture, and some of the examples I've seen have been very light on in terms of detail. One case where the young person returned to country, I asked for more detail, and it was purely to play basketball at a stadium on country once a fortnight. It was an in and out. That's not connection. So that appropriate cultural due diligence needs to occur.
Yeah.
Thank you.
I've got a question
Go on.
to ask,
Go.
isn't
Okay.
it? An exception to the fact that the delegations of long-term guardianship orders sit with you both. In regards to an Aboriginal child or a young person, in that instance, where will you get the level of Aboriginal input to help with your decision making as to whether an application is warranted or not warranted? Because I'm thinking about, for yourselves, having regard for the standard of active efforts before it even gets to the court, who might provide an accountability with regard to
Can I make just a
that
brief
standard.
comment just on that? I think about two things. One is that chief executives and deputy chief executives are not jobs for life. So I'm really mindful that at some point something will happen and that we will be out of role. So I want to future-proof the critical priority work that we focus on. So whilst we have an Aboriginal DCE with a what I hope is a culturally appropriate lens, we want to make sure that's not just a point in time where it was good luck we had someone there. We want the system to continue with those values. Sorry, Jackie, you.
No, and Adam, I'm just going to build on that actually by saying that, and again, it's not so as a non-Aboriginal person, it's not for me to seek assurances in regards to the documentation. It's for them to evidence to me. It's a really strong thing that I do believe that I have a very critically inquisitive sort of approach to what I do, and it is clearly that if it isn't demonstrated to me within that documentation, I'll always take the guidance from Adam anyway, and I will always seek counsel to Adam and others in for that matter, Commissioner, but also as well, it is for others to critically inform me rather than me to justify views of others.
In a cultural sense, I'm acutely aware of the importance of not speaking for other Aboriginal people without permission from appropriate elders, and that resonates with me all the time in terms of what I see as the power that comes with the role. So my commitment in this, and with all decisions around Aboriginal kids, I have my own value set and my own opinions, but I like to test them constantly. And when I talk about future proofing, it's creating that process of whoever's in the role with the delegation, what is a reasonable, from community standards, process of testing the eligibility to continue with that process. And I don't think it can be internal. I think it has to be a partnership assessment going forward.
And I think, and one of the things I just want to touch on as well is Adam and I had quite lengthy discussions prior to his appointment, really, about the role that we wanted him to undertake, and it was not just about, it wasn't just about ensuring that we had a system that was responsive to Aboriginal children. It was all children. There was definitely some consideration there in regards to ensuring that he fulfills the entire role. And of course, in doing so, there was some definite prominent things we both wanted to do around Aboriginal children. But it was also as well really mindful that it's about the entirety of the role to actually significantly make those particular changes to this system that's sustainable, really. It wasn't just about while we were in it, us being tested in that system. It was like, how do you really change this system? How do we bring community into this system?
Mm-hmm. Thank you. We've already touched on it, but the inquiry's heard a great deal of evidence about the Western attachment theory and its lack of cultural appropriateness when being applied to Aboriginal families. And those models don't account for Aboriginal child caring practices or consider the practices in a strengths-based manner. We've heard evidence that with respect to the Aboriginal attachment theory, Aboriginal children form significant attachments to multiple family members as kin, as opposed to the Western idea of the nuclear family and there being one primary attachment. In making decisions about permanency planning, it appears from the evidence that we've seen that the Western model of attachment is relied upon by the department to justify the non-viability of reunification with the family, particularly with very young children who've been removed. And it occurs in both ways. Both the Aboriginal child rearing practices, namely having many family members and kin residing or moving through the home, is seen as a risk factor. And also the department don't wish to interrupt a child's perceived attachment to a carer. The DCP staff noted during the workshops that attachment is used as a barrier, with the system not pursuing family or kinship placement opportunities for children who are seen as settled, in the Western sense of settled, in long-term care arrangements. Does the department acknowledge that the differences in Aboriginal child rearing practices and attachments exist, and how those differences should be considered when the determinations about Aboriginal children and families are being made?
Yes.
Absolutely, we do. What to take comfort from there as well, councillor, if that's the voice of the staff group as well, that is really heartening for us to hear, because we're definitely hearing that from a leadership perspective around what we need to do there. So if that's what's coming through in your consultation as part of this inquiry, that's really heartening for us
It's being
to build on.
recognised.
Yeah, yeah.
Good. Sorry, Council, just to add to your comment from before about I sit in a mainstream role, the learnings from some of this will have profound and positive impacts for other groups in our community. Yes. And I know from my engagement with our multicultural services staff and some of the leaders in the multicultural community in South Australia, some of these topics are of significance as well in terms of the Western approach to family and kin. So I think only good things can come by respectful curiosity into the evolution of the interpretation of primary attachment.
Good, thank you. Has the department undertaken, or does it intend to undertake, any consultation with the Aboriginal community and experts in the field of Aboriginal attachment theory to inform its practice and policies and procedures moving forward?
My conversation, Jackie referenced earlier the director of the Aboriginal Practice Directorate that we have. One of the topics for further exploration, and it's also the Kitty's team, the practice and policy branch within the organisation, to do some research into our own assumptions around primary attachment, but also some desktop research on other jurisdictions and other countries in terms of the interpretation and the evolution. Part of that to me will be engagement with community to get a voice and help inform our understanding of not only the differences in the attachment theories, but also the value for Aboriginal children with the broader interpretation for kin. So the answer, yes, there'll be engagement with community.
Can I ask a question in relation to that
Sure.
research? Because there are a raft of Aboriginal and Torres Strait Islander experts in Australia, as well as the cultural context from Aboriginal community members themselves about what Aboriginal child rearing practices are, Aboriginal ways of knowing and being, and I am concerned that there'll be another layer of research. We know what the issue is.
Yeah.
We know what needs to happen. I'm wanting to understand whether the department will be able to apply that knowledge that's already known into operational policies and procedures, into the way in which you engage with psychologists and psychiatrists to make those assessments versus someone who's actually quite skilled. The assessment from a cultural context, the assessment tools that go with that. I think there's a raft of research that already provides what is needed. The question is about the system, how it actually integrates that into its structure systemically, so that it benefits the Aboriginal child.
I think Jackie. I think part of that too is going right upstream, right back into the university space. For those studying social work and other allied health professions that lean into child protection, changing the perception of attachment all the way back then, because when you look at the change we're trying to introduce now, there are people with years of experience where that has just been a fact, primary attachment, full stop. So rather than having to change people's understanding here, we think going upstream with communication, but also trying to influence some of the content in delivery will also help that longer term. But the point that you make, Commissioner, in terms of how we make sure this occurs for an experiential perspective from families' view, etc., is all of those components. So it's ensuring that it's embedded in our policy. The only reason I've supported that desktop review of existing things is to make sure we're setting the argument up for success, so we can reference the trends across other jurisdictions that support the argument that this is of benefit. Then, like when we were talking about the comparison with this continent and Europe in terms of the various countries within that, those local conversations about what are the key priorities for you in terms of attachment in this context, and making sure that that's all reflected in what the landing, or I guess the end point is in terms of our collective interpretation. But it certainly won't be us doing a desktop review of existing reports and then saying this is it, and it won't be something that drags on for years, because the research could do that. The conversation is contemporary in a lot of parts of the globe. So our view is to capture a sense of what are the themes that relate to our priorities, test those with our communities, and then to come back with a position for the department in terms of how we expect our staff to apply that interpretation.
I'm not sure. I think because for me, it's the question, the justification about why you want to change things is already evidence.
Can I respond to
Maybe I haven't heard.
No, because can I just build on that? And I'm just saying this really authentically to you in response to your question as openly and honestly as I can. And really, when you talk about our practice and our policies, and I hear you loud and clear that the research has been done, and what really resonated with me is when you talk about the way of doing and knowing, and I think alongside what Adam's saying in regards to different positioning, or while that jolting's going around in regards to how we demonstrate that, our practices have to recognise it, have to recognise that those references on attachment and theories and ways of knowing need to be embedded in our policies now. And it's not for us to determine if that's there or not. It's for us to actually, that it's not for theirs to determine on what does that look like, how does it look like. Because if you're a non-Aboriginal person, to determine that, you've got to recognise going in our policies, does it reference an Aboriginal attachment theory? Does it reference the sort of child rearing principles? Does it reference that? And then who are we to sort of not acknowledge that? That's an acknowledgement. So you test that theory with your PACs and what it is around how it's been demonstrated. And I think you can back that up with, research or whatever. But in the absence of that, it should be that ways of doing is demonstrated and is outlined in in our practices and our policies, really.
And we shouldn't have to do it, but it is,
yeah.
it's that academic world that we're, because if you think of the clinical background and the way that that's framed and purported to people, it's taken as fact.
That's
Whilst
exactly it,
whilst
yeah.
we know
Yeah.
Aboriginal way,
Yeah.
it's making sure, and it is almost translating Aboriginal way into that Western clinical way. So there's two pieces. There's the, we can influence the change in practice, but we also want to have that meaningful shift in perception around attachment more broadly. And that's the reason for the investing in that more research part. But it shouldn't prevent us from changing practice in terms of our staff. I just think that there's a bigger piece there which is about changing people's perception
100%.
in the clinical space around primary attachment.
Probably wasn't articulating it that very well, but what I was thinking exactly the same, Adam, is if in other areas where there's some clinical aspects of it, we don't drill that down in a policy procedure. It's a fact, it's a knowing. So in this particular case, our policies and practices should actually reflect that, and it should just be accepted that there is these theories
Your
and not
policy
tested.
documents do say that.
They do,
They
yeah.
do, and they're
Yeah.
clearly not being applied.
But not, that
No.
it's been tested around
Yes.
what that is. Mm.
The other issue we have is that the department will rely on psychiatric or psychological reports and family assessment reports that are very Western-centric. So how do we get past that in terms of applications being made to the court that you've got, you know, an expert report who'll come and give evidence in the youth court to say that no, this child's attached to this one person and it would be detrimental to remove that child from that placement.
And I think that does speak to the work that we have to do in that regard. And you made reference to Dr. Tracy Westerman previously. Those are the things that need to shape some of our thinking around some of our clinical service and provisions that we have here, because we accept that they are currently at the moment through a range of tools and applied through that particular westernised lens. Yeah, we have to accept it.
In fact, one of the expert witnesses, Dr. Yvonne Clark,
Yeah.
clinical psychologist, is now working in the university sector, previously developed or adapted the family relationship test, or the assessment tool regarding attachment and bonding, because at one time she was employed
Yeah.
in your agency
Yeah.
some time ago. Is that tool that she developed, that adaptive tool around family relationships, is that still in place in your agency?
I don't know, Commissioner, actually. I don't know. It's the first time I've had reference to that. When we, I'm just talking from my own perspective, when I've asked about tools, I've asked about, are they culturally appropriate? Are they does the community recognise these as validated tools that recognise culture? I've not heard reference to that, so I'd have to take that on notice in regards to what that is. But
With respect to connection, issues around transfer of guardianship, the department's adoption from care policy states that Aboriginal or Torres Strait Islander children or young people will not be adopted from care. Do you agree that the intent of this policy is to prevent Aboriginal children from being permanently removed and disconnected from their family and culture?
I've got fairly subjective views based on my own journey, so can I ask you, Council, to ask that to me, or
Sure.
to us again, just so I can...
So the department's adoption from care policy states very clearly that Aboriginal or Torres Strait Islander children or young people will not be adopted from care. So would you agree that the notion behind putting that policy in place was to prevent Aboriginal children being permanently disconnected from their culture and their family?
I think that's a reasonable assessment.
Yeah, absolutely.
So then, in terms of the number of Aboriginal children who then move into long-term guardianship orders until they're 18, how is there any difference?
It's, in terms of the experience, it would be the same.
Thank you. We've heard evidence from experts in the area that say that reunification of Aboriginal children must be the aim, the ultimate aim for children wherever possible. And your policy states that DCP caseworker must ensure that any decisions about the viability of reunification are made within 6 months for children under the age of 2 years, due to their critical need to develop the secure attachment relationship with the caregiver, again, which is based on that Western model, and within 12 months for children or young people over the age of 2 years. We've heard significant evidence in the inquiry that due to the intergenerational trauma and the complex social determinants that are known to impact on Aboriginal families, the timeframes for reunification and for those decisions being made are simply not realistic or culturally appropriate. That's exacerbated by the lack of resources and the substantial waiting times for the services such as drug and alcohol counselling. So it can be a 5-month wait to get into drug and alcohol counselling. If you've got 6 months to address your child protection issues, you cannot possibly meet that demand. So how do you propose to address that lack of opportunities for Aboriginal families to pursue reunification of very young children?
Well, I think the focus on reunification, certainly since certainly me undertaking the role, has been really evident in regards to the department, the government's commitment around reunification efforts. I absolutely wholeheartedly agree in regards to the lack of service provision that is available for families to ensure that their engagement in those services attribute to their success at that outcome. And I think the commitment and the if I may reference that there is a whole of government chief executive governance group which is chaired by the minister to be instrumental to ensuring that provisions of services are made available for children in child protection and family support, and it is with that intention of ensuring that we can get services to families effectively with agreeance of those particular more favourable outcomes of reunification. Now, I don't think that's going to happen overnight because of the there is a capacity within service provision, but I don't feel at all compromised as the head of child protection of advocating so strongly about these children and why it should be these children. So, being a strong advocate, across government for those particular types of interventions, I see as a critical part of my role, and I don't apologise for that when people ask me why those children and why not the services, etc. I don't apologise for that at all. So, I think we have seen some better outcomes around reunification. I think we need to have better options for Aboriginal children in regard to reunification, and there is more of a requirement on those particular service provisions for those families if we're going to be successful at those outcomes as well.
Thank you. So the requirement for timely decision making under the most recent iteration of the Act effectively means that families are given less time to address the child protection concerns. And if I can take you to the graph number 6, it indicates that there's a trending down at every stage, 6 months, 12 months and 24 months. There's 3 consecutive pages there that show
That's for reunification.
the trends, yes.
Yeah.
So the rate of reunification of Aboriginal children has decreased by up to 20%. Sorry, I
Apologise. Sorry, I've got that.
has decreased by up to 20% over a 10-year period. So given those trends, how can the government possibly meet its commitment to reduce the number of Aboriginal children in out-of-home care?
Yeah.
It does feel like the interpretation of timely has translated to a literal arbitrary number. When I think of the term timely, it's an appropriate time for the situation that presents before us. One thing I would commit to doing next, I would like to look at the actual wording of the legislation around the 6 months and 12 months deadlines to see what are the opportunities for delegated interpretation. We need to create some flexibility so that each system response is tailored to the needs of the family and any of the issues that are presenting for that family. So, for example, if it is 5 months for mum to access a drug treatment program, that we could look to what are our options around changing the timeline so that mum's afforded that opportunity to have the time to respond. I can't answer that in terms of what it is now and what delegation exists for us to look at, but to me I see a real missed opportunity if we don't look at creating that flexibility around what are currently hard targets. And if that's an interpretation of the term timely, I would ask for a different interpretation, because it seems just like a perverse side effect. In prima facie, just looking at it, I don't feel that's the intent. So I'd like to go and do a bit more work.
So the legislation states timely, it's the policy that sets
Yeah.
the timeframes.
But I'm pleased because that gives us a lot of room to be able to have that. Yeah.
The Minister for Child Protection and Family Support and the chair of the Child Protection Expert Group led a symposium a couple of weeks ago, and one of the real big takeaways for me was where you had a biological parent of a child who made reference to the department's lack of advice, information and support early on the removal. She wasn't disputing the removal. She wasn't disputing her the need for the matters that she was facing to be addressed. However, that clock is ticking before she articulated openly to that symposium that had she known earlier that these were some of the requirements of the department or the ask of the department on her, she could have entered into those sort of service provisions, etc. or that, and that really resonated with me in regards to again, it doesn't, even regardless of whatever term timely or the provisions that we set in the policy, that really sat with me that, if we don't articulate that to these parents, then they don't know the clock's ticking. They don't know that, one of the ways that we're going to assess if their, reunifications, could be offered would be because of those provisions that we put on. So it's that whole thing of, right, we need to have that engagement and communication more.
And just building on that, Ms. Bray, one of the criticisms that's regularly made in youth court proceedings in terms of moving towards long-term orders is that the client or the parent has failed to engage. But surely it's the department's responsibility to engage with them rather than expecting people who are traumatised, who are dealing with grief and loss, who have got the complex, multi-layered child protection issues to engage with the department.
100%. And absolutely, when we look at other models, other jurisdictions, international practice, you actually see that the engagement or failure to engage by a parent, it should not be a significant consideration alone. It should be the representation of another social worker, another engagement, another opportunity, building on those particular practices. So I do know, overseas, for instance, the removal is not in regard to lack of engagement. We represent another social worker and another one until that engagement opportunity occurs. And we all know that that could happen at any particular point or with any other level of engagement.
So is that something that will be addressed?
That is something that we are looking at as sort of saying, why do we look at that? Why do we look at an engagement or lack of engagement as a particular aspect there?
And it's a shift of, it's also, it's the system owning responsibility for that instead of the blaming. But it's consistent shift in language and perception, because we use the same narrative in our communication when we have failed to find a kinship placement. The system notes will reflect no kinship carers came forward from the family. Well, that's quite a subjective comment, but it's all linked back to our cultural journey, but it's a similar example.
Absolutely.
As it stands now, currently reunification is considered prior to a long-term order being sought, and then once the order is made, it's rarely ever addressed again. And it's not something that is revisited.
Agree.
So, and again, it's the pulling in of the attachment. Even if parents do put in the hard work and address the problems that have brought them into the child protection, they could front up to the court and be told, I'm sorry, we're just not going to do that to the child, to remove that child again, without recognising that the initial removal was traumatic for everybody involved. But the workshops of your staff reflected that Aboriginal families are just not given enough support to achieve a reunification, or any sense that once a removal is made, it's permanent. It's not going to be addressed again. Does the department intend implementing culturally appropriate tools that might assess the attachment of Western children to address this and give opportunities for Aboriginal parents to come back 2 years, 3 years, 4 years down the track and seek reunification with their children?
Look, again, I've entered into this particular role with a view that because guardianship has been assessed in that, there is nothing in that provision that talks about it never being able to be revisited again. So my check-in on that is that should happen. But I think, Council, to be honest, we've missed a step there. We've missed a step of the right of that child to be still connected to family, the right of that child to be connected to siblings, the right of that child to be connected to community. And in that, with that right and with that engagement throughout their life, that might represent reunification opportunities if given. So that's the step that's missing for me as well. Children that are under those long-term orders really, to me, represents that there's not a further action to represent at court at that moment in time. Not that there should never be, and that's a view that I particularly hold. I don't know, it is my view, but it's a view that I hold, and we would see more of that if we had that level of connection with, we fulfilled the rights of those children.
Right.
Yeah.
Thank you.
As it stands, the system doesn't have it doesn't give the impression that it allows for growth and change.
No.
And I think that by maintaining that connection, it's also a benefit because there's contemporary observation of the presentation of the biological family and how they're travelling. I think that, and I know we referenced in this conversation in relation to revisiting long-term orders, and I think it was focusing more on those longer-term foster care arrangements, but there are even children in residential care where we haven't gone back and said, you know what, I wonder how mum and dad are going.
Oh, no.
And that comes back to that, what I think we're going to learn in this process we're undertaking now, that by making time for staff to be able to do those more in-depth but very important tasks, we'll start to see a shift in that. The view that people can't change or people become typecast based on our last interaction, and then we can sort of suddenly realise we're 2 years down the track and we haven't actually reconsidered. You can't really defend that. So I think that needs to be an active part of our efforts.
Agree.
Thank you. The department's own review of the Act noted that for Aboriginal children in particular, it was recommended that a child's case plan and annual review should include a specific section on reunification. That review heard that the option for reunification should remain open and for active efforts to support parents to seek reunification at all points of engagement with child protection. The evidence before this inquiry demonstrates that that's absolutely not the case in practice. Do you agree with that?
I would agree with that.
And would you agree that there needs to be a significant shift in policy and practice to meet those standards of active efforts?
Yeah.
Thank you.
I think it needs to go a step further, because I would hate for child protection workers to think that this is all their fault. It's incumbent on us as the executive and indeed government to make sure that staff are afforded the time and the tools to do their job properly. It's very easy to say, put another policy or put another recording mechanism over the top, which staff will interpret as just another person attacking us.
Sure.
If we give staff the time and we make sure the right staff are in the right roles, and I see the benefit having a lot more Aboriginal staff, that will make the most profound change of any strategy, I think.
But you'd have to concede that there are a number of Aboriginal children who shouldn't be in care.
Absolutely. And that's indefensible. But I do worry sometimes when there's a narrative about the system and what it needs to do, that staff may interpret that as that's their fault, that they have a role and they have responsibility and accountability. But I think broader, the system has a duty to make sure, if we're in this most important of portfolios, that the staff are set up to be able to do their job appropriately. And at the moment, their workload and other commitments means that these important tasks aren't getting the attention they need.
And the system needs to be set up to ensure that those children and their families who don't need to be having contact with the statutory system stay away from the statutory system.
Absolutely.
And the workforce that you have only dealing with those children and their families that need to be in that environment.
Exactly right.
Yeah. Moving on to cultural maintenance planning. Issues identified by your staff acknowledge that Aboriginal children in out-of-home care were given inconsistent opportunities to connect with family, community and culture, with the variability in how that contact was managed across your various offices. Key reflections included that the child protection system could do more to support connection, arguing there is too much focus on the placement as such. Children were not being given enough opportunities to connect to culture and country, especially when placed away from community and country. There is a need to understand the difference between cultural events, return to country and family contact. For example, we heard that having a child attend an NAIDOC week event was considered appropriate and adequate connection to culture in some situations. And better partnerships with community were needed to support that connection. Some of the participants discussed the challenges and the barriers to supporting connection, which included challenges connecting children and young people to culture when the family themselves were completely disconnected from that culture and community, a lack of policy direction and guidance regarding the return to country arrangements, with current practice being ad hoc and the funding being inconsistent, the need for ongoing access to cultural mentors, noting that currently funding is only for 2 years per child, and inconsistent use of the Aboriginal Cultural Identity Support Tool, including examples of in case files where that tool, the forms for that tool were just left blank. The issues associated with identification included inconsistent and incorrect information on your DCP files, as between agencies regarding the Aboriginality of a child and which clan they might have belonged to, and if that was wrong, that wasn't often connected. Then the storybooks being really just nominal, not actually being anything that's meaningful to the child or their culture or their family. And the other issue was people falsely identifying as Aboriginal, and then de-identification, how that should be dealt with and explained to a child. What is there that the department would consider appropriate to do in circumstances where these issues have been raised by your staff?
Yeah. So in other jurisdictions, the reference around the cultural plans or the cultural support plans was an intent from government to ensure that connection occurred and that it was meaningful, and it was normalised as part of the response to support a young person. It was mandated, but what we saw were cultural support plans populated with cultural information from a Google search. We saw cultural plans with a NAIDOC event. We saw really basic, and in terms of compliance, and I won't state the jurisdiction, but it was roughly 50% in terms of completing these. And then you should actively review them, and of course the annual reviews didn't occur for cultural plans. They are an amazing tool if they're used properly. What I trialled with my team was to change the paradigm of the cultural support plan so that the plan belongs to the family. The plan itself is designed to hold government across different portfolios accountable to have a consistent and culturally immersed lens into those various domains for a young person. So, for example, if a young person was engaged in the youth justice system, child protection, if they were going to school, the plan would be shared with all of those stakeholders if family gave permission, with the view to being the education plan can link to the cultural plan. In relation to any youth justice matters, the justice plan can link to that, so that we can find areas of commonality where there's strength in culture to push forward in all of those domains and start normalising the inclusion of a cultural connection for our clients across all of those different parts of the service system. It was hugely successful in terms of bringing staff on that journey, and I think in terms of our numbers in that patch went from about 50 to 92%, and it wasn't just for child protection, but it was profound for teachers in terms of the engagement and their cultural learning as well. So whilst I am 5 months in, this is something I would be really keen to pursue, not as a mandatory tick box exercise, but for a meaningful tool that we design in partnership with our communities to ensure that we and our colleagues across government, and I think the CE's Forum is the perfect platform to seek commitment to this, in terms of all of us leaning in and having a consistent value for culture for our young people across all of those service systems. I think if the Commissioner would be so gracious as to help us, I would love to work on this with your guidance as well. I just think if you get it right, it is hugely powerful. If you don't, it becomes just another layer of tick box and why even do it.
Thank you.
Sure.
Thank you. The next topic we've got now, I understand we're running, it's about 6 minutes to 3. I think we can probably get through this in the next 10, 15 minutes. Family contact arrangements. The workshop notes that some of your participants, staff reflected that the approach to family contact was far too focused on just contact with the parents and not considering the connection with family and culture or any community contact opportunities. How could the department address that issue?
It's been bubbling for a while because they've set up a contact review process. So I assume that came about because of the number of instances where agreement couldn't be reached on contact. I have some issue with that in terms of why it's a thing. But for me, what I would like to see is a way for particularly Aboriginal families to be able to say, hey, you haven't got the contact right, and someone to address the power imbalance and actually go through it methodically to see what's in the best interest of the child. One thing that comes out a lot is sibling contact, and we focus just on the biological parents, as you said, but the siblings, when you think about that relationship and the significance over life, is huge, and we're inadvertently taking that away from children. So the contact is an area of great focus for us. I think the panel, if there are grounds for it to be reasonable and to exist, and I honestly don't know, I haven't looked into it enough, there needs to be an equivalent for Aboriginal families as well, because unless you apply an Aboriginal lens, they're two very different dynamics when we talk about family contact, and particularly when we talk about the attachment theory. So for me, it's something I'm still quite new at. Jackie's had a few extra weeks on me in the role, but My take is there is this process. I'm not sure of its value, but if it is valuable, there needs to be an Aboriginal equivalent to that.
Sure.
And I think in the absence of any other suggestions, it was something that we immediately come to a point of going, well, what do you mean? You know, where's the Aboriginal representation? I know there's other views around the actual purpose and intent and where that should be. Notwithstanding any of that, there's still something for us to turn around and say, we can't hand on heart turn around and say that is culturally appropriate at the moment. So that alone.
One of the submissions we've heard is that the decision about the amount and frequency and when and where and who, with respect to family contact, is not a decision that should have been delegated to a government department in the first place. It should be a decision that's made by a judicial officer based on evidence. What would you say to that?
I have heard that view. I think in the absence of my broader knowledge around the reasoning behind it being a recommendation, obviously in the Royal Commission.
And within my inquiry preliminary report. Yep.
Indeed. For me, it's as I said, it's something that I think we need to really deeply listen to and get consideration around, you know, where that ultimately sits within the legislation. But again, I'll just go back to sort of in the absence of that, and however long that was those changes are to be made. I still think that there is improvements that we can make to our current arrangements that sits currently with us.
And one of the other issues that we hear as practitioners is that the department workers work from 9 till 5. Anything outside of that is not able to be supervised, not able to be arranged, not realistic in terms of how families operate. So a family celebration on a Sunday can't be participated in. Christmas Day is a huge issue for people because none of your workers work on Christmas Day and they're not going to transport and they're not going to be there.
Yeah.
That's heartbreaking for parents 100%. And for children. Yeah. That, you know, is not realistic in terms of how the world operates. So is there anything we can do to address that?
I think there's lots. I think about pre-COVID, for example. I was in a jurisdiction that was slightly more impacted than South Australia in terms of the COVID experience, but we still had that statutory responsibility for child protection, and it made us rethink. You know, we have this association with the building, the place, the hours of the day. We were able to respond in a very different way. I'm hoping to bring people on a journey of more flexible work arrangements, and I accept that Christmas Day could be problematic, but I also celebrate our diverse workforce where many staff don't celebrate Christmas and would much rather have a day off another day or to be remunerated to do something above and beyond on that day. I see capacity, but it needs to be give and take, and I don't feel at the moment our staff necessarily see the opportunity in terms of being more flexible. So I think that's probably something for us to turn our minds to, about creating that environment where we can have greater flexibility. Some staff may wish to work earlier in the day and finish earlier, or alternatively, you know, have a weekend as a work day and change things. That everything in that space should be negotiable, and I think that would lend itself nicely to starting to respond to that in a meaningful way.
And I'll just add that it might not ever materialise, but the conversation hasn't happened. When we have that conversation, it hasn't happened. So, what, you know, that's the first step. But again, it might not materialise. We might not. But it's how then do we make sure that how does our system respond differently? Yeah.
And it would also apply, I imagine, to sorry time, so that children, can connection to culture, go back with family to be part of that, because it's such a fundamental part of culture, but it's just not a possibility that's considered very often.
In terms of sorry business, it's the Aboriginal staff will lean in heavily. We tend to make it work, so we'll drop everything, we'll put plans aside. The system doesn't lend itself to supporting that well, and that's something we need to focus on.
Thank you. Difficulties with administering policy regarding contact determinations was noted, highlighting that although kinship carers are permitted to manage contact with family members, all of them needed a contact determination which was not feasible for all extended family. So if an Aboriginal child is placed in a kinship care position, there needs to be a higher level of trust that the carers are capable of making some of the decisions about how there's integration and how there's connection with the family. And community members without that constant surveillance and oversight from the department. Do you agree with that?
Yeah, and I think this is when I first arrived this morning, when I talked about, I'm certainly going to make some inquiries about that decision-making, consultation aspects that's going on with our carer group. I think that really lends itself to that as well, Council, in regards to. I feel quite assured that all carers, specifically kinship carers, will have a view on that. Certainly, those in the last 6 months I've spoke to in regards to them being critical part of that decision making. We only met a couple yesterday. You and Adam and I only met a couple yesterday morning, having that specific request to us.
Thank you. Participants in the workshops also reported that there were different approaches to sibling contact across different offices, and noted that challenges with siblings lived interstate or in different placements and where carers didn't take on the role of facilitating contact was very problematic. Do you agree that children's connection with their siblings is fundamentally important connection that must be maintained?
Absolutely.
Yes, definitely.
So how is the department going to be able to address that issue?
Yeah.
We've started having a lot of conversations with our staff where we say, why haven't we thought bigger, or why haven't we tried something more bold? And it's particularly relevant when there is distance between sibling contact. The response is there hasn't been an authorising environment to encourage that. And that's not a criticism, that's the response to this blowing out expensive part of the system. We hope by investing more in connection and opportunities and empowering staff to be bolder in that space, that will have a positive reduction on the need for this to grow. And we are also confident that that will reduce with the other initiatives. We aim to make this far more normalised, and for staff and families and carers to be able to say, we have these two young people, would like them to spend some time together, what's something we can do? And if there is distance, well, we could make that into something special. That could be a let's all go somewhere, or let's do something. So it's important that staff are supported to be able to do that, because I believe that's something they do want to do. That's what they say.
And if I were just to build on that, I think that, and even just at the weekend when I was at an event with kinship with carers, kinship and foster carers, I think that is more normalised in those environments. I think where we have some work to do is in our residential care. I'm not saying at all it is in every other sort of caring environment, but the sense I get is that, the introduction I get with, the little ones and my big sister and my little sister and the different sort of family members that they're with, I think that's it's more prevalent. I think that we have a specific issue in residential care with sibling contact. Yes.
I have heard from children who aren't in care, but they may have siblings in care, and their challenge about contact with their siblings is very worrying for them, that they're not heard. Their ability to be able to have support is an issue for them, but more so for the child in care, like I'm talking about the Aboriginal child in care, in terms of contact with their siblings. What is the plan for the department for all those children who have siblings, whether they're in care or not, to ensure that, because I've heard from hundreds of Aboriginal children that they hold on to their loved ones which is usually their siblings and their parents, immediate family, but the rest of the family, their other attachments. But a pressing issue is their siblings. What is the plan?
Well, I think the first step is in our manual of practice. It is in there. It talks about the requirement for us to do that. What we need to make sure is that actually is enacted, and that sort of information is enacted, and that requirement for our staff is implemented. I know that the reason I looked at Adam immediately when he asked that is because that is something which is front of mind, and even only yesterday we were talking extensively around how we're going to lead into that. The plan there has to be that narrative around, if we're interested, other people need to be really fascinated in this, because it has to be from the top. It has to be under our leadership that we push that down, that is something that has to be implemented and looked at.
We're probably 2 weeks into the exploratory and design phase of a sibling contact initiative, and that's something that's come out initially, obviously, from your preliminary report, but also from the conversations we've had with carers and with families in terms of that need to focus.
Good, thank you. Placement of non-Aboriginal out-of-home care increases the risk of loss to connection and culture. Our workshop participants from the DCP acknowledged that placement, with some participants reflecting that Aboriginal children in long-term non-care arrangements, including family-based and residential care placements, were often completely disconnected from their Aboriginal culture. This is the child you spoke about earlier. That's right. Some participants commented that non-Aboriginal carers just simply lack the training and the guidance to support any realistic connection. How does the department intend to address the issue of the disconnection from culture when children are placed in placements with non-Aboriginal carers?
I think in terms of the original decision, we've talked about some of the processes that we're going to utilise to ensure there's a cultural lens over all of those. The work that we're hoping to achieve in terms of the barriers for kinship placements will have an impact as well. The part of, I think, the priority in terms of having a stronger carer's voice is to make sure that we are responding to carers to ensure they are afforded the training, the tools and supports to have children thrive in their care. Whilst I would accept the view that the cultural proficiency in the carers group currently may not meet the needs of children, I do think there's an appetite in our carers cohort, particularly with non-Aboriginal carers. There's a goodwill and an intent, but without the knowledge and training, that manifests in all different ways, where the carer who said, let's do the NAIDOC event, or whoever was responsible, probably genuinely thought they were doing the right thing. To me, I think working with the carers group that's been established, we can start a conversation about what does that look like, what is the need from your perspective, and we can share with you what we're hearing from the Aboriginal community perspective and bring a conversation together with those parties to start looking at what can we proactively do to change that. I think we are very focused on ensuring that we respect, engage and maintain our carers, but at the same time I think we need to make sure that the focus on supporting the carers does not diminish the connection with the biological family and culture, and I think that's probably been our gap. I would say confidently that's been our gap in the past.
One of the other big things as well has been about a training program for our non-Aboriginal carers. And as I looked at the training calendar and program, there was references to some Aboriginal, some cultural training, and it was clearly not enough. However, positively, when I asked carers about their particular cultural training, they thoroughly enjoyed it and found it very informative, and they wanted more too. So that having a schedule for carers now was a great opportunity, and certainly being welcomed by carers. but I think we need to build on that momentum now and actually see more of that particular cultural awareness, cultural training, engagement. Really, that sort of getting carers more proficient in their cultural understanding is definitely something which is an immediate feedback on that.
Thank you.
What do you ask of in terms of licensing agreements and contracts with NGO in this regard, ACOs, in relationship to recruitment of carers for Aboriginal children? Do you have a percentage of how many should be Aboriginal carers, or there is no context to the carers? Because historically that was the position of the previous Aboriginal foster care agency, that it would only recruit Aboriginal carers for Aboriginal children,
Yeah.
mostly kinship carers in that regard.
Yeah.
What is the department's position on contracts and licensing for ACOs in relation to the cultural background of carers to drive
Yeah.
the outcomes for our children?
I wonder if it's worth referencing the work for our CFO in the review space at the moment.
Well, we can because, more than happy to do that, because I personally can't answer that fully, respectfully, to the Commissioner. So I think I know that we've got things in train to ask some of those questions, but yeah, do you want to?
Yeah, I was just thinking there were a number of questions similar that I had in terms of the content of the current contractual arrangements, and although the issue you've just mentioned that I hadn't yet, but I will certainly add that to my list. I'm wanting to see across the board in terms of the different contracts and what are the requirements, and who is putting the contract requirements in there. I suspect at the moment there's opportunity that we haven't taken for Aboriginal staff and stakeholders to help with the content of some of these contracts. And at the moment, if there is reference to requirements and milestones, etc., in the Aboriginal space, that I wouldn't be confident there's an Aboriginal lens over that from a compliance perspective. So that's something that I think A, will take on notice, but B, I would be keen to speak further about what we change going forward, because there's a gap there which is a big opportunity.
Some of the participants in the workshops felt that long-term residential care placements increase the risk of a young person's involvement in problematic behaviours, and discussed the impact of staff turnover and skill levels in managing trauma-related behaviours on the ability to build relationships and support young people. Is the department focusing on addressing the staff issues and training for staff in those facilities to provide Aboriginal children with a sense of safety and security with the people they care for?
Definitely, there's a strong focus and some collaboration in terms of our work with PSA around changing the environment to attract and retain staff. The relationships are critical, but I would come back to our commitments around reducing the numbers of children in that space as well.
Sure.
And it would be remiss of us not to mention the sanctuary model around what's happening in residential services, but also residential care as well. But also as well, quite recently I went to the Nunga Resource Centre down south, and those amazing opportunities that are presented there, which as a leadership team we really want to lean in regards to having those cultural sessions for our young people that are in residential care, in those environments, in those safe environments by Aboriginal staff, and then really how we can extend that into that broader residential care modelling to enhance that.
Is it not true that if the state is going to interfere and step into the fundamental relationship between a parent and a child, and remove a child due to inadequate parenting, then it should and could be expected that the standard of parenting that's provided by the state should be significantly better than that from which the child has been removed. Do you agree with that?
It's a reasonable assertion.
And one said to me before by an Aboriginal woman who'd had her child removed.
Do you consider that the state provides a significantly better parenting environment for children who are removed from parents at the moment?
I think the commitment that I took to undertake this role as the Chief Executive of this agency was to do exactly that, Council.
Thank you. I think that's about all my questions.
I have one question before we wrap up. And it goes back to the connection point and to the Aboriginal Cultural Identity Support Tool, is that an Aboriginal child in care should have a cultural mentor. Sometimes if they're in kinship care with strong cultural practices, that's often identified as a significant family member from that child's Aboriginal context. For many Aboriginal children, because we know what the statistics are, that they aren't afforded a cultural mentor that we would expect as set out in the expectations of the case plan and the Aboriginal Cultural Identity Support Tool. And I've heard on a number of occasions from Aboriginal children and young people about the fact that that requirement is not given to them around a cultural mentor being appointed. What are the plans for the department to ensure that every Aboriginal child, and particularly in relation to the Aboriginal Cultural Identity Support Tool, will receive a cultural mentor that, one, is meaningful, two, that will truly be able to provide them the connection to their cultural identity and their family, particularly for those who are in non-Aboriginal care?
This is another one of those where I think the English literal interpretation of mentor occupies the space. So when I think of cultural mentor, I think of that auntie or uncle of significance that will take me on journeys and expose me to activities and participate in significant events that connect me to culture, and that it's a safe space and it's, you know, there's an element of fun involved. For me, when we apply a literal interpretation of mentor, I think that's where we narrow the scope of the people we could be calling upon to support in this space. It's the same as when we think about cultural camps and time away on country for kids, particularly kids in residential care. It's such a palaver to pull together, but at the same time, if there's a school camp, it's just a couple of forms and the job's done. Like, these are things that we should be normalising and just making routine. So in terms of the mentor work, I think there's a great opportunity for us to expand that further. I know there are conversations with our ACCO partners wanting to support having a greater presence there. There would need to be the conversation about any remunerational costs associated with setting that up, and they're conversations that we'll have. But I do think there is a significant deficit in not having a mentor program for every child that wants that, and I'm more than happy to commit to leaning into identifying how we can expand that within any relevant constraints, but to find a way forward.
Yeah, and it is explicitly an Aboriginal person.
Absolutely.
Not anyone from an ACCO. Cultural mentor as defined specifically from the context of the Aboriginal child, as well as the Aboriginal community, in regards to meeting their development around their cultural identity.
Thank you very much. We'll finish that there.
Thank you.
Thank you so much for your attendance.